Please give me that. And then you can take that to the clerk's office whenever you go.
So, I'm sorry.
Scan it to me and then just take it to the criminal clerk whenever you go.
Gotcha.
Kavanaugh Flats versus Michelle Washburn, 25-0834. Appearance, please.
Good morning, Judge. Christopher Asphalt, 53129 on behalf of the plaintiff.
Good morning, Your Honor. Sierra Oliver, P87707 for the defendant.
Okay, today is the date scheduled for hearing. This is for non-payment of rent. I do have a consent order for conditional dismissal. It states that the case will be dismissed today upon the condition that you agree to pay past due rent, $3,800. That's for rent due through a period of the end of this month, February 28th, 2026. That you'll pay that plus court cost of $181.77 for a total $3,981.77. That you'll pay that balance and move out before March 9th, correct?
Correct.
Okay, you understand that you have the right in this matter to proceed to a trial and you could have demanded a jury trial? Why are you looking at her?
I'm sorry, I didn't hear you fully.
Well, then that's just, let me know.
Okay.
Do you understand that you have the right to have a jury trial in this matter?
Yes, ma'am.
Do you want to waive your right to trial?
Yeah.
Is anyone threatening you to do that?
No.
Anyone coercing you to enter into this agreement?
No.
Okay, partial performance will not satisfy. This, you need to do exactly what you said you're gonna do, which is pay the full amount or vacate by the 9th. Otherwise, the plaintiff can request judgment to enter against you and remove you from the property. You will not get a new court date. You understand that?
Yes.
You have 3 business days to return to the court. If once you leave here, you realize you in fact misunderstood your right to trial, you can return to the court, request to have this agreement set aside, okay?
Okay.
You have any questions at this time?
Okay.
Any additional matters for the record?
Nothing further, Your Honor.
No, Judge.
Thank you. Get your copy of the paperwork.
Thank you so much.
Under 2/8 just requested adjournment.
Let's see, Capital Manor Lansing versus Tadrika Coney, 25-08144. Appearance, please.
Yes, good morning, Aaron Rombach here for the plaintiff.
Good morning, Your Honor. Sierra Oliver, P87707 for the defendant.
Tadrika Coney.
Yes.
Okay, today was the date scheduled for hearing for non-payment of rent and parties want a adjournment.
Yes, Judge, there's a ledger issue that I think we can reconcile. Looks like there's a payment that had made that hasn't been received or credited on our ledger. We can figure out that discrepancy. We can probably enter into a CD.
That's correct, Ms. Oliver.
Yes, Your Honor.
Sorry. 1 week adjournment is sufficient? February 25th at 9:45. February 25th? Sorry, 9:45.
Thank you, Judge.
No
Thanks very
problem.
much.
Any additional matters on this record?
Nothing further, Your Honor. Thank you very much.
Thank you. Good Deal Properties versus Lewis Garrett, 25-08209. Here's for the record.
Kristen, 58192.
Okay, and you are, who is this?
Mr. Markovich, owner of Good Deal Properties.
Okay, you can have a seat. We're not going on the record, correct? We're not doing a hearing today.
No, Your Honor.
Okay, you just need a new date.
I think so. Mr. Lewis is CV counsel. I think we originally had a settlement agreement, kind of worked out, but then there was a term that was obviously there was some discrepancy, so.
A settlement agreement of which kind?
Your Honor,
No, I'm asking the
Oh,
attorney,
I'm
give me what kind of settlement agreement, a conditional dismissal or a consent judgment
It
or?
would be a consent judgment. We were gonna allow them to stay in the property and so forth. The parties have worked it out themselves. I had no part of it. And then when we got here today, apparently there was one aspect of it.
That was concerning for, okay, what's the
Yes.
issue, sir?
So I gave a lump sum as a settlement to the landlord.
You've paid a lump sum since when?
That was just 2 days ago,
How much?
$4,000. This was for an agreement, a verbal agreement that me and the landlord had came upon about a week prior, with that being a settlement for him to dismiss this case this week. So prior to,
You paid $4,000 with the understanding that that would dismiss this case?
no, ma'am, we had an agreement that it would.
That's what I'm saying, that
Uh-huh,
means
yes,
with the
ma'am.
understanding,
Yes, ma'am.
there's already an agreement. Did he take the $4,000?
You take $4,000.
He can come up. State your name for the record.
Andrea Marte Markovich?
Okay, you had an agreement with him to accept $4,000 to dismiss this eviction?
No, we have an agreement that we would get a consent judgment towards the balance of the 10,300, which I'd give him up to like 2 years to pay for. And then.
Is that what you came up with today with the attorney?
No, this is what we talked about before the attorney got involved.
A consent judgment?
Yeah, the agreement is what we.
No, no, you said a consent judgment. You talked to them about consent judgment prior to the attorney getting involved?
Yeah, well, we
No,
talked about.
yeah, no, well, you talked to him about a consent judgment prior to the attorney getting involved.
No,
You use those, thank you.
the term, I guess I'm using incorrectly. So the agreement is that he would get up to 2 years to pay the balance of the 10,300 after he paid the 4,000. And then from there, he could stay in the building for till May 30th to give him plenty of time to move out of the building.
Just a verbal agreement you had?
No, Your Honor, what the verbal agreement we had was that I would pay a lump sum on the back, which would erase the back, and then going forward up until May 30th, he would require me to pay the rent or not. I agreed
How
to
did you
it.
all discuss this agreement?
We was over the phone, but I also sent him a message stating everything that we said over the phone, and I
You sent a
did.
text message?
Yes, ma'am.
You have a copy of the text message?
Yes, ma'am. Can I get it?
Yes.
I don't have a copy of it.
I didn't ask you if you had a copy of it. This is what is a screenshot?
Yeah,
Per our verbal agreement, I am sending payment based on your agreement to cancel the pay to quit hearing scheduled for February 18th, 2026 with Judge Kristen Simmons. If you do not intend to cancel the hearing, please do not accept the payment. Did you receive payment yesterday?
I have received
Did
payment.
you accept the payment?
It came through, but it hasn't.
That's
hit
not my
bank.
question. Did you accept the payment?
He owes me money. I would, why wouldn't I?
Okay. Show me where you sent this because it's a screenshot.
the secretary actually sent it, but
Who's secretary?
mine.
What do you mean your
She
secretary?
handles the payment and everything, so she sent me what she was sending to him.
No, the text message? So the text message came from your secretary's number?
Mhm.
Is that a yes?
Yes, ma'am, I'm sorry.
Okay, okay, and is your secretary here?
No, she's not, but I can have her
Okay.
present.
You're gonna need to bring your secretary with proof that she sent this message. If he brings me some proof that that message was sent, this is dismissed. He entered into an agreement and he accepted the payment. I don't believe that he talked about a consent judgment before you. He's not even giving me a straight answer, which makes me lack credibility with him. I don't trust anything comes out of his mouth at this point. Because when I ask a direct question and you try to play me, then I don't trust you anymore. I asked him very clearly, did you talk to him about a consent judgment? Yes. Do you think that I think that he talked to him about the words consent judgment? I do not.
I use those words.
Yeah, I know you do. That's why I asked before the attorney got involved. But I know he didn't do that. Do I believe that he entered an agreement with him prior to you becoming involved? Absolutely. He accepted the payment under these conditions, if that's what the text message says. It very clearly says, if you don't accept this, do not receive don't take the payment. He accepted the payment, so that means that he has entered into an agreement, because that's how contracts work, isn't it? You put the terms and conditions, you accept by accepting the payment.
Hasn't hit my bank account yet.
Doesn't matter, you accepted the payment. And so I'm gonna have him bring proof that that was sent. You obviously got the link, because I see the above where the link says that it was sent from that same number on the screenshot. He can bring or have your assistant, whoever it was, log into Zoom for the next court date. The two of you all are gonna appear in person. If he provides proof, this case is dismissed. February 25th at 9:45. February 25th at 9:25. Do you have any questions for the court?
No, ma'am.
Any additional matters for the record?
No, ma'am. Or actually, as far as case being dismissed, when will be my notice to get out? Because it's a commercial property and I have a lot of things in the building, so I need to know exactly what I would need to make.
You all can work that on. You already worked out this. This case is dismissed. You would either have to refile or you all have to work something else out. Because he accepted if what you're saying is something you can prove, then he accepted agreement to dismiss the case after he takes his $4,000. At 9:45? 9:45. Thank you.
Thank you.
This is Woodbridge Apartments versus Samuel Majak, 25-08548 appearance.
Morning, Your Honor. Robert Visconti, P 61756.
Today was the date scheduled for eviction. This is for non-payment of rent. No one's appeared for Kevin or Samuel Majak. Is that correct?
That's correct.
Okay, so default or enter.
Brown.
Get your copy. Let's see. Woodbridge Apartments versus Kevin Brown and all other occupants, 25-08527.
Robert Visconti, P 61756. All this is
Table. right here. Stay right there. Thanks.
And you are Mr. Kevin Brown?
I am.
Okay, today was the date scheduled for hearing. This is for non-payment of rent. I have here a consent judgment. It says that the parties consent that judge will enter against you, Mr. Brown, in the amount of $4,821.03 plus cost $176.54 for a total amount due $4,997.57. Correct, sir?
That's correct.
And that you'll either pay that in full or vacate the property in question by March 2nd, 2026. Is that correct?
Yes.
You have the right to be represented by an attorney during this eviction. Did you understand that right?
I do.
And you wanted to waive that right today?
That's correct.
You also have the right to proceed to trial. You could have demanded a jury trial, or we could have had your hearing today. You understand that, sir?
I do.
And you want to waive your right to have a trial?
I do.
Anyone coercing you to enter into this agreement?
Not at all.
You have 3 business days from today's date. If once you leave here, you realize you misunderstood the right that you waived, you can return to the court, request to have this judgment set aside, and we'll set it for a hearing, okay?
Yes.
Do you have any questions at this time?
None.
Any additional matters for the record, counsel?
Nothing further, Your Honor.
Thank you. We'll get you a copy of your paperwork, sir. Ventura Flats versus Anthony Macias, 25-08592. Appearance.
Good morning, Judge. Christopher Asphalt, 53129 on behalf of the plaintiff.
Okay, you are Mr. Anthony Macias?
Yes.
Okay, today was the date that was set for hearings for non-payment of rent eviction. I do have a consent judgment, Mr. Macias. It says that you will enter in judgment against yourself for $1,393.39 plus court costs, $181.77 for a total $1,575.16, correct? Okay, and that you'll pay that in full or you'll vacate the premises in question no later than March 2nd, 2026, correct?
Yes, Your Honor.
You have the right to be represented by an attorney. You understand that, right?
Yes, Your
How does this sound? Okay, that's. Okay, you also have the right in this matter to proceed to trial. You could have had a jury trial, or you can hold your hearing today. You understand that? Do you want to waive your right to trial or hearing?
Yes, sir.
Anyone coercing you to enter into this agreement?
No, Your Honor.
You have 3 business days from today's date to return to the court and have that set aside if you later realize you misunderstood those rights, okay?
Yes, ma'am.
We'll get you a copy of your paperwork. Any additional matters for the record, counsel?
No.
Thank you, you're all set. What bridge part is versus, that must have been dismissed. I just did it. That's all. Carolina Flats versus the Tara Simpson, 25-08128. Appearance, please.
Christopher Asphalt for the plaintiff.
Okay, is Tara Simpson here?
Oh, she is here, Judge. I'm still speaking with her in the hallway.
Oh, okay, very good. You're ready on the Houston. Is that yours?
Yes.
Okay, Ventura Flats versus Natasha Hoosman and Brandon Hoosman, 25-08597. Appearance, please.
Christopher Asphalt for the plaintiff.
Good morning, Your Honor. Sierra Alver P-87707 for both of the defendants.
Okay, your name, ma'am?
Natasha Hussman.
Your name, sir?
Brandon Hospital.
Okay, I do have a consent order for conditional dismissal here. It says the parties agree to have the matter dismissed today upon the condition That the past due rent is paid in the amount of $1,420 plus court costs of $175 for a total amount due of $1,595, and that's for rent due through a period of February 28, 2026. Correct? Okay, and that the plaintiff will timely adjust the ledger to reflect the balance in section D2. That beginning March 2026, defendants shall pay $400 on or before the 10th of each month and $400 on or before the 20th of each month. This is in addition to the defendant's timely rental obligations. If defendant makes timely payments, no late fees to accrue. Plaintiff shall accept a promise to pay from a third-party agency that agrees to timely pay all or part of the defendant's balance. That's accurate. You have the right in this matter to proceed to trial. You could have demanded jury trial. You understand that? Do you both give up your right to have a trial? Okay, and no one's coercing you to enter into this agreement, correct? Okay, partial performance will not satisfy this. You gotta do exactly what you have, you say you're gonna do there and pay that amount when you say you're gonna pay those amounts. Otherwise, the plaintiff can request the judgment to enter against you and you will not get a new court date. Do you understand that?
Yes, ma'am.
Do you have any questions at this time?
No, ma'am.
Any additional matters for the record, counsel?
No, Your Honor.
Nothing further. Thank you.
Thank you. We'll get you a copy of the paperwork in just a moment. On the record in the matter of Carolina Flats versus Tara Simpson and all other occupants, 25-08128.
Christopher Asphalt for the plaintiff.
What's your name, ma'am?
Sarah Simpson.
Okay, Ms. Simpson, today was the date scheduled for a hearing. This is for non-payment of rent. I do have a consent judgment. It says that the past due rent to retain possession is due in the amount of $888 plus court costs of $180.68 for a total amount $1,068.68. You agree with that?
Yes, ma'am.
And that you'll pay that amount in full or vacate the premise in question by the 2nd of March 2026, correct?
Yes, ma'am.
Okay, you have the right to be represented by an attorney. You understand that, right?
Yes, ma'am.
Are you waiving that right now? Means you're giving the right up. Do you want to give that right away?
No.
Okay, you want to get an attorney to represent?
Oh,
you?
no, I'm sorry.
Okay. Okay, you also have the right in this matter to proceed to trial, or you could hold a hearing on this matter. You understand that?
Yes, ma'am.
And are you willing to waive or give up your hearing today?
Yes.
Anyone coercing you to enter into consent judgment?
No, ma'am.
You have 3 business days to return to the court to have that set aside. If you realize you misunderstood your rights that you've just given up, you can request to have that set aside, okay?
All right. Thank you.
You have any questions, ma'am?
No, no.
Any additional matters for the record?
No, Judge.
Thank you.
All right.
No problem. Sorry, here. My iPhone is doing some weird stuff. What happened?
My toner be out of my printer.
This is in here.
Yes, you did.
I need my fan in my office fixed too.
Oh, I got it. I talked to Mace about that. I got it.
It was hot in there yesterday. I don't know why this is doing this. So my iPad did this update, and I don't even know how to use this thing anymore. That's crazy. You sent your date. I did, I didn't see you. I don't think I have it. I need to just send me an email. About what? From the bucket, but I don't. I sent it on 30th. I don't think I did. Hold on. I don't think I CC'd you. Are you all ready, Mrs. O'Berry, or? You are ready? Okay, I don't know where the other part is.
I can look at it.
Thank you. This is the matter of Wanda Moss versus Brooke Sandiford. This is 26-00003, Council Affairs.
Billy J. O'Berry, Peace 37689, on behalf of the plaintiff Wanda Moss, who is seated to my left here today.
Fulham Law, P 77932, present on behalf of the defendant Brooke Sandiford, who is present and seated to my right.
This matter was scheduled today for a hearing. This is for termination of tenancy. Did you all resolve it?
At this point, we have not resolved it, Your Honor. I think, as I said at our last pre-trial, this is a situation my client's not a tenant and never has been. She was simply living with a boyfriend who was renting from the plaintiff, his mother. It became clear that the plaintiff in this case did not want her living there. She did leave. So she never had an agreement to pay any rent to the plaintiff or anything like that. If I could tell the court about what we discussed for you in the hallway, if that's all right.
I don't know what are you talking about. I think that's something. You
Yep.
made an offer.
So your position is that your client doesn't live there?
That's correct. Now, we do acknowledge there's some furniture and things like that she's left behind, and she does stay the night there because she is a tenant, Jackie Moss's girlfriend. My client notes that she has, is that 2 beds and a dining room table? Yes. That are still there, that are in what were previously empty rooms of the house, and she has the tenant's permission. She has Mr. Moss's permission. to reside there.
Okay. And what is your client's position?
My client's position is that beginning in August of this past year, that Ms. Sandifer actually moved in without the permission of my client. The understanding was that they were going to talk about entering into some kind of rental agreement or whatever. They kept stalling. We get to October, Ms. Moss sent them a notice saying, okay, this is how much his rent's gonna be, and this is how much her rent's gonna be, because she moved furniture and clothing and all that.
So she disputes and she believes that the defendant still lives there.
Yes.
Okay, well, we can proceed with the hearing today then. You call your witness.
Your Honor, I have what my client has brought with me today, a power of attorney that she would like for her daughter. She said she has some hearing difficulties. This has caused her a lot of stress, and she would like for her daughter to be able to speak on her behalf.
Did she hear what I'm saying? Can you hear me?
On and off. I
Okay.
didn't hear much of what you were saying.
If you don't hear, just raise your hand so that we can know, okay? We typically have a hearing thing in here, but it's not working.
All right, I'll try to speak up as well. I have a soft voice as well. I would like to call to Talise Wesley, please.
You can be seated. You raise your right hand. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury? You can have a seat. State your first and last name and then spell both.
Wesley. H-L-I-S-E-W-S-L-E-Y.
You can proceed, counsel.
Thank you, Your Honor. And are you familiar with the plaintiff here today seated at my left?
Yes.
And how do you know the plaintiff to my left? Okay, and her name is?
Rhonda Moss.
Are you familiar with the situation regarding the property at 2508 Victor Avenue? Michigan?
Yes.
And who is residing at that residence lawfully at this time?
My brother Jackie Moss and Brooke Sanford are there.
All right. And do you know if there's a lease or rental agreement at this time for this property, occupancy of this property?
There's no register, no written lease. You want to come on and see.
Are you familiar with a letter that is dated December 2nd, 2025, marked as our proposed exhibit number 1?
Yes.
I'm going to show you our proposed exhibit number 1. And do you know the reason for this communication?
Yes, it was disputing rental amount, the amount that my mom said that was owed for rent. It's disputing and asking for negotiations for the amount.
Okay, were you present during conversations with the tenant that is there, Jackie Moss?
Yes.
Okay, and what was the agreement with Jackie Moss?
I'll object to hearsay.
I-
Jackie's not a party to the case.
You're objecting to hearsay because it's going to. She was present and she was involved in this conversation?
That's my understanding. Yes.
But any agreement, any verbal.
When you're talking about
agreement-
hearsay, then you're talking about, he's not a party, so you're talking about relevancy too, I'm not understanding how him not being a party makes it hearsay.
Because he's not here.
Well, that has nothing to do with him being a party. No. So he doesn't have to be a party for that to be hearsay, but if she can give me direct testimony because she was involved in that conversation, then it's not hearsay. So the objection's over.
Thank you, Your Honor.
But that's only if she can give me direct testimony.
Is it that you can give direct testimony about the discussion with Jackie Moss about the amount of rent?
Yes.
All right, and what was the amount of rent to be with Jackie Moss?
Jackie was paying, he was paying $1,000.
Up until what time?
Up until the notice was given,
Would that have been in October?
the notice was given in October. That was. now that
Notice of what? I'm confused.
Notice of a rent increase.
Okay, got it.
I'm gonna go back to this document because I haven't finished up with it. Who was this document from?
This was from, it was sent from Brooke's email address.
Okay, and does Brooke discuss paying rent to Miss Wanda Moss?
She discussed rent. She asked several questions about how much is her mortgage, what is Jackie's inheritance. It asked lots of questions.
Okay, and was that letter received after the emails about the rent increase?
Yes, that's how, yes.
As of October, what was the rent to be for Jackie Moss and for Brooke Sandifer?
$1,250
Each.
Yeah.
$1,250 per person?
Yes.
Okay.
And the home or the structure that is involved at 2508 Victor Avenue, what type of property is this? Is it an apartment, is it a house, a condo, what?
It's a single family home, 4 bedrooms, 3 baths, fenced yard. Very nice property. And the Zillow, if you look it up on Zillow, the estimate is the rental rate is like $2,600 a month. So this was well in, fair market value. And the discussions when the property was purchased were that, I'm doing this to help out my
I'll stop you,
son.
because there's no question, you didn't object,
Okay,
correct?
Correct.
You can only answer questions, but since you didn't already got that out without an objection, I want to know, were you present for these conversations when the property was purchased?
Oh, yeah,
Okay,
I mean,
because Jackie's your
my brother.
Okay,
I
so
went
you were
look-
president, well, since you were president, you can continue to tell me. What was the conversation when the property was
The
purchased?
conversation was, I am buying this home for you to live in, to help you get a start in life.
This was the conversation you had?
No, I was there.
Oh,
with-
this is, your mom says this?
Yes.
Okay, got it.
Yes, to give you a start in life. And if anyone, when you're ready to move someone in, there will be a rate increase, because $1,000, she was explaining to him, I'm in the hole. I'm going in the hole having you live here with only $1,000. I'm doing this on behalf of.
Because you're my son, got it.
Yeah. helping-
Okay,
Yeah.
you can continue the question, your witness.
I'd like to move for admission of our proposed exhibit number 1.
Any objections to plaintiff's one?
Yes, right.
Yes, it is.
I don't think this is the proper witness to authenticate it, but we're not going, for the sake of judicial economy, we're not going to dispute it.
Okay, plaintiff's one is admitted, it's been marked. We have a sticker. You can admit and publish to the court.
This is the third page to this.
Did you say there are stickers, Your Honor?
I have it,
Oh, okay.
but she has the rest of them if you need any more. This is all one exhibit?
Yes.
Okay.
Action. I think we have.
Yeah, there's the third page.
Here.
So would the third page be like the middle page maybe?
It was last page, there was
A list of
a
questions.
list
That
of
has, oh,
very
okay,
inappropriate
got it.
questions.
I have no objection for this to be substituted instead.
Okay,
So you'd rather have this be substituted?
what is, this is the email?
Correct, it's the same thing, but there was,
Can you make a copy? Does he have another
I have
copy?
copies.
Okay, sounds good.
right, he had it.
Okay, so let's see. Same email. I already put the sticker on there, so I'm just gonna attach it like this. We can proceed.
Thank you, Lauren. Do you know when Ms. Sandiver moved into the address of 2508 Victor Avenue, Lansing, Michigan?
I know that she started moving in October, or excuse me, she started moving in August. Because she installed like a closet system, so she started moving things in then. But officially, when she was supposed to be paying, the rent was supposed to start on November 1st, or November 16th.
Okay, I'm showing you an email that's marked as proposed exhibit 2A and 2B. Are you familiar with this proposed exhibit? You have personal knowledge of this email.
This text message, yes, I have seen that.
All right. And when was that sent, if you know?
Let's see.
Two, A. Should be up here.
This was sent on October 14th.
And what is your understanding about the rent to be paid by Ms. Sandifer at that point, beginning November 16th?
That it would be $2,500.
Yeah.
Or excuse me, the full rent is $2,500.
Did I hear the plaintiff correct some of his testimony? That's not proper.
I would agree.
I'll object to that.
Objection is sustained.
Thank you, Gary.
So this says for the total for two, I'm sorry, I was reading this, the total for two is 12. The total for two is 2,500 is what it says here. So half of that.
All right. Now, this is a text message. Are you familiar with that conversation?
Before we go any further, I
Yes.
believe I'm missing a third page of the text message of the copies I got for opposing counsel. If you pass that along. You indicated there were 3 pages, I only have 2.
June.
to our account.
So, and this was in October. Is that correct? That this communication was sent to the best of your knowledge?
Yes.
So I let these marked as exhibit, what was exhibit 2? To your knowledge,
Okay.
did,
No, she said 2A and 2B. Is it 2A and 2B? That's how you want it marked or just,
yes, 2A and 2B.
okay. She marked it.
Are you moving for their admission at this? point?
Yes, I'm gonna move for their admission.
Now?
Yes.
Okay. I do have some more here questions. That proposed exhibit, was that from your phone or for someone else's?
No, that is from, I saw it from my mom's phone.
All right, so that text message was not sent to you?
It was not sent to me, no.
And I do object on 2 grounds. One, it contains statements from someone who's not testifying, which is Jackie. And secondly, this individual is not the person whose phone it is, and they're not proper personal authentication.
Your voice is dropping just a little bit.
I'm looking down, sorry.
No worries.
I do object on 2 grounds. The first is hearsay because it's the statement of Jackie Moss, who's not present, is not testifying. And furthermore, it's from someone's phone that is not the witness's phone. Therefore, she's not the proper person authenticated.
Did you want to respond to the objection?
Yes, Your Honor. I had asked this witness, Ms. Wesley, if she saw this text message, and she indicated that she did on her mother's phone.
Okay, and so I'm trying to understand the purpose of this witness testifying on instead of this witness. I thought it was because there was maybe some kind of power of attorney that warranted it. She's in open court corrected this witness. She can take the stand and needs to at this point.
Okay, I'll reserve.
Okay, thank you.
2A then.
Objection sustained.
Thank you. Did you have any, were you present with any further conversations, Ms. Sandifer, about her, let's withdraw that question. I'm sorry. You made the statement that in August, Ms. Sandifer installed a closet unit.
Yes,
Where was that installed?
in one of the bedrooms, that's turned into a closet.
Okay, how do you know that Ms. Sandifer installed that closet organizer?
She told me,
That was a conversation directly to you?
yes,
And do you know if she used that closet organizer at the property at 2508 Victor?
yes. She showed me pictures at Thanksgiving.
To your knowledge, is that closet unit still at the property of 2508 Victor Avenue?
As of February 11th, it was there still.
After October, to your knowledge, did Ms. Sandifer pay any rent to Ms. Moss for residing at the property?
No, to my knowledge, no.
Have you been to the properties since the first of the year, January of 2026?
Yes,
And what did you view in the property as far as furnishings?
A lot of the defendants saying,
All right. How do you know they're defendants' things?
because the property was furnished when my brother moved in, my mom furnished.
Okay, so what things were different after Ms. Moss moved, I mean, sorry, Ms. Sandifer moved in?
There's a living room set, a TV, a bedroom set. Lots of boxes around.
Okay, I'm showing you what marked as proposed exhibit 5, 5A, 5B, and 5C. Can you identify these photographs? What's in these photographs?
This is the living room set that's in the second living area. This is the her dining room set. She made my brother get rid of the dining room set that was in there for that one. This is like a dresser type set that's in the spare bedroom with her bed, and I know it's her bed because I had given my brother a headboard set that was in there that's now moved to the basement. So,
All right, so do these photos accurately represent what you viewed as recent as February 11th of 2026?
yes,
Right, I move for admission of our proposed exhibit 5 through 5. What are the last numbers?
I have 5A, 5B, and 5C. Is that all you have up there?
5A, B, and C.
Well, there's 5 and then 5A, 5B, and 5C. So
Yes, that's correct.
4 total.
The other thing is, you need to retrieve your exhibit 2. Like, I don't know, did we finish admitting that? No. Okay, you're gonna withdraw, you're gonna hold that one until you call the next one. It's got it. Okay. And then no objection to 5A, 5B, and 5C.
Again, for your questions, Your Honor.
Proceed.
Did you take those photographs?
not so. I have video from that day on my phone that I took personally.
Then I will object. So, do you know who took them?
Yes, my mother, she's in the video that I'm recording, taking the photos in the video.
Then I will object. Again, because this is not the proper way to authenticate those. And as Your Honor noted, the proper person to authenticate those exhibits is present and has already corrected this witness once.
That objection's overruled. We get photos taken by anyone. She can identify in the picture if she was present, what she sees. Just like if I were to have a victim sitting here and the police took pictures of the injuries, the victim didn't take their own pictures. I still can admit those exhibits. So
Thank you, Your Honor.
the objection's overruled.
Thank you. I would move for admission of 5 through 5C.
5 through 5A, 5B, and 5C are admitted.
You mentioned earlier that this home, you are familiar with the exterior and interior. I'm showing you what's marked as proposed exhibit 3. Does this accurately represent the home that we're talking about at issue in this case?
Yes.
And what is the approximate value according to Zillow of that property?
$257,700.
Okay, and then you indicated in your testimony earlier that the rent could be around $2,600. Is that correct?
The estimated rent on here says $2,622.
All right, I move for admission of our proposed exhibit 3.
I'll object as to relevance when this isn't an actual appraisal that was done by somebody who specializes in those types of appraisals. And secondly, I don't see the relevance. What's really relevant here is whether there was a lease between these two parties.
The evidentiary value of this is to show me what the fair market value would be of the home.
Yes.
Okay, well, I don't need that as an exhibit. I can take judicial notice.
All right, thank you.
Thank you. So that's not, an-
Then I'll withdraw request for admission of number 3. Have you had any opportunity to text Ms. Sandifer between February 11th and today's date?
I have not sent her any text between those dates now.
Okay. To your knowledge, has Ms. Sandifer paid any rent since she moved in August and installed a closet organizer in this property at 3508 Victor Avenue?
My knowledge, no, she is not.
Do you know if Ms. Sandifer is still staying there? At this address?
To my knowledge, she is.
Are you aware of any notices, written or verbal, text, email that have indicated that I no longer reside at this residence?
No.
Thank you. Okay, thank you. I have no further questions for this witness at this time.
cross exam.
Just a couple of questions. Do you acknowledge that there was no written lease between your mother and my client?
There was no written lease.
And there actually currently is no written lease between your mother and Jackie at this point, is there?
No, there's 30 days, month to month.
You testified earlier regarding a closet system. Or a closet, changes made in the closet. I can't remember how you described it. Can you remind me?
After the closet system.
Okay. Were you present when that closet system was purchased?
No,
So
she told me. The defendant
when you
told
say
me-
she,
The defendant told me that she put in the closet.
that she put it in herself?
She said that she ordered it and she told me, after that was a conversation with her and my brother, that they weren't installing it.
So when was the last time you were at the subject premises?
February 11th.
Did you see my client then?
On February 11th, I did not.
And was that February 11th of this year?
Yes.
Did you have a verbal conversation with my client within the past, this month, February?
Yeah. Yes.
Regarding whether she was still living there? Carol, come in with my client. Isn't it true that my client told you that she no longer lives there?
She told me that she no longer lived there, and I said, why are all of your things here? And she said, I have nowhere to store them. I have given these things to Jackie. And I said, that is not fair. You cannot circumvent the law, because as soon as you find a place to live, you're gonna say, I want my things back. Or if you guys break up tomorrow, I want my things back. that would be the narrative, then that's the conversation that we had.
Didn't my client tell you that if her and Jackie broke up tomorrow, those items that she had left there would be his?
Yes, and he's supposed to be getting that notarized.
So in essence, that's being taken care of between Jackie and my client.
We're waiting on that because otherwise my mom is prepared to ask for those belongings, that those belongings remain with the house, the property. Because she's not running a homeless shelter or a storage facility.
And nothing further.
Any redirect?
Did Ms. Sandiver indicate that she was going to pay rent for any months prior to her claim that she moved out?
She didn't.
All right. You said that she told you that she was going to leave these items there, is that correct?
Yes.
And in one of the exhibits there, I'm gonna show, let me show you something.
Are you referring to exhibit 5?
This, no, this is.
This one has.
I see this before.
No. No, don't. I'm showing you our proposed plaintiff's proposed exhibit number 6. Is that, have you seen that closet organizer at the house?
Yes.
Okay, does that picture accurately represent what you saw at 2508 Victor Avenue, Lansing?
That's the closet system, yeah.
And that was the closet system that you had the discussion about with Ms. Sandiver?
Yes. This, yeah, she showed me pictures.
I'd like to move for admission of our proposed exhibit 6.
Any objection?
I have a few more good questions. Do you know when that picture was taken? Thank you. I'd like to have a look at it. Do you know when that picture was taken?
I don't know. when the picture was taken.
Okay. When was the last time you saw that specific closet organizer that's here at the top?
Saw the whole thing, I mean,
What-
in the room on February 11th.
But you don't know when this picture was taken.
No, I do not.
You know, it's okay.
My mother had that picture.
And you weren't there when it was taken.
I don't know when that was taken, so I don't know.
And what is it on the bottom here? Bottom section? that you're claiming belongs to my client?
Like the island,
Okay, is it the island? Here that I'm indicating.
the
with my
island, the
thumb?
rug.
Were you present when the bottom photo was taken?
I don't know when either.
Then in that case, I do object.
Your Honor, I offered it to ask her if this was what she saw in the property, but I will reserve.
It's submitted for that purpose.
Okay, thank you. Thank you. I have no further questions for this witness at this time.
You can be excused. You can call your next witness.
I'd like
Could I have a brief moment with my client?
Absolutely.
I'm ready to proceed.
You can call your witness.
All right, I'd like to call Alvin Moss, if I may.
Thank you.
He just wants to put more money.
Oh, that's okay.
Cool. So there's another witness that you need to call.
Alvin Moss, but he went to put money in his.
Okay.
name, So I'll proceed with this, Ms. Moss.
Thank you.
Wanda Moss.
You raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, I do.
Thank you. You can have a seat.
Ms. Moss, will you state your complete name for the record? And if I talk too low, let me know, okay? And are you familiar with the property at 2508 Victor Avenue, Lansing, Michigan?
Yes, I am.
And do you know who Jackie Moss is?
Yes, I do.
And who is Jackie Moss?
My son.
All right. And where does Jackie Moss live?
Private in Victor Avenue, Lansing.
All right. Do you know approximately when he moved into that property?
2019. May, I believe.
All right. And did he pay you rent to live at that property?
Yes,
And how much did he pay you in rent?
$1,000 a month.
All right. And this is quite a large house. We've had an exhibit, or the judge has taken judicial notice of this house. And it's a 4-bedroom, I think, two baths or 3?
4 bedrooms, 3 bathrooms, 2 living rooms. A dining room, sunroom. Kitchen, stage basement. 18 yard, and 2-car garage.
All
You
right.
said 2 living rooms and a sunroom and a dining room?
2 bedrooms, you said 2
No,
living.
4 bedrooms, 3 bathrooms,
You said 2 living rooms,
2 living rooms,
a sunroom
a sunroom,
and a dining room.
dining room, kitchen island, stage basement, 2-car garage, fenced in yard, large backyard.
Thank you. This sounds like quite a nice home. And the rent of $1,000 seems very reasonable. Is there a reason why the rent wasn't more?
Because he's my son, I love him, just wanted to help him get a head start in life.
All right. And when he moved in there in 2019, how many occupants were there at the property?
1,
And that was who?
Jackie.
And how long did that continue?
If it continues to be, he is still.
Did there come a point in time where you told Jackie that he owed more rent?
Yes.
And when was that, if you know?
Probably a couple of years ago, but I enforced it, November 1st. Yeah, November 1st last year I enforced it.
There's a proposed exhibit, I believe, 2, that's a text message to Jackie. Were you communicating with Jackie via text messages?
Yes, I was.
And did you at some point in time advise him that the rent was going to be more, that his rent was going to be more?
Yes, I did.
And how much did you tell him his rent was gonna be?
His rent alone would be $1,250,
And that was to begin when?
starting on November 1st,
Of
2025.
2025, okay. How many occupants were there at the property at that time?
At that time, there were 2 occupants there.
Okay, did you say anything about the second occupant?
Yes, I said the second occupant would have to pay the exact same amount.
Okay, and who was the second occupant?
Second occupant was the defendant.
And would that be Brooke Sandifer?
Correct.
Did you ever enter into a written lease with either party?
No,
Did you ever have a written rental agreement with either party?
no,
And did you discuss doing a rental agreement or a lease at some point in
yes, I
time?
did.
And with whom did you have that discussion?
I had the discussion, with Jackie. Legal perspective.
Okay, okay. And that text was as of November of 2025.
Right. November 19th, 2025, legal perspective.
And
Can you
how-
speak up a little bit? I can't hear you. The defendant and my son responded in a text, November 19th, 2025.
Okay, I'm showing you our proposed exhibit 4 and 4A.
He responded twice, actually. Once in text and
Okay,
once-
okay, wait just a second. Let me ask you a question. I'm showing you our proposed exhibit 4 and our proposed and 4A. Does that text message look familiar?
Yes, and we do not feel comfortable with the additional, thing.
Okay. So there was an acknowledgement that you were asking for more money, is that correct?
Correct.
But they were saying they didn't want to pay more money,
Yes.
and that was in November, correct?
November 19th, yes.
Okay. I would move for admission of our proposed exhibit 4 and 4A.
I have a couple board here questions.
Okay.
At the top. At the top, it just indicates Jackie. Is that correct?
Correct.
You said earlier they responded, but this appears to only be from Jackie. Is that correct?
I said they responded because it said uncomfortable and because I received a letter, email letter directly from the defendant on December 2nd, 2025, acknowledging the same thing.
But that's a separate exhibit. The letter.
Separate exhibit,
But this particular text message only came from Jackie. Is that right?
correct?
Okay. Then that's fine.
All right, I would move for admission of exhibit 4 and 4A.
That may be a minute.
Thank you. was, and you said, I believe exhibit 1 should be the letter that's been admitted, dated December 2nd, 2005. Is that correct, from Brooke Sanford?
Correct, and I was also verbally, it was also verbally discussed with the defendant and myself.
Okay, where were you when you had that discussion?
December 5th. When I did the inspection. 2025. I'm sorry? December 5th, 2025. What happened then? I didn't hear what you said before that. Verbally discussed that the rent amount couldn't be paid, and I was doing an appraisal, having an appraisal done on the house. They couldn't afford it, I was gonna have to sell it. Okay.
So did you discuss the amounts that each were to pay in that conversation with them?
No, it was already in writing.
And you, while you were there, you said December 5th, did you take photos at that time?
Yes, I did.
There's been photos that have been admitted, and I think I'm showing you exhibit number 6. Are you familiar with that photo?
Yes, I am.
And how are you familiar with that photo?
During my December 5th inspection, I took.
Okay, I'm going to show you. So while you went through the house, did you take photos of different rooms in the house? And that was when?
First one was December 5th, 2025.
Okay, I'm showing you proposed exhibits 7 through 10. What are these photos, if you recognize them?
The first photo is shows the defendant's dining room set. She replaced the one that my son had there. And then in the back of that, it's a bar set. I'm apparently going. You said in the back of that is what? It was a bar set. Okay.
Do these pictures, you don't need to go through each one, but do these pictures accurately reflect what you saw there that date on, I think you said December 5th?
Yes, the second picture, bottom of 7 is the second living room. The home has 2 living rooms. That's the second living room, and that's the defendant's sofa and ottoman.
All right, how do you know they're the defendant's sofa?
When I furnished the home when I bought it, and that appeared around that time, around the December 5th, before December 5th, I guess. Okay.
So would you say these items shown in this picture were placed in the house after the defendant moved into the property?
Yes, and the defendant said that she had given everything to Jackie on a visit, a February visit. She said everything she had given to Jackie.
I would move for admission of proposed exhibits 7 through 10.
I'm not sure she's looked at every single one of them.
Okay, and just so I can make sure I have the last statement correct, you said it was a February visit that the defendant said that she'd given everything to Jackie? Yes. Okay. Yes. February. Okay, this February. Yes. Okay, thank you. She said with the exception of the pack boxes, she said that those were not his. The pack, all the pack boxes were hers.
So she, they were still there February 11. She said the vote was her.
Okay, so what day in February was this?
What day was this that you're talking about in February?
It was a Sunday, probably the first Sunday, or the first Sunday in February.
Okay, so first Sunday you went there, she said, the defendant was present, told you that she had given the furniture items to her boyfriend, your
Yes,
son,
with the exception of,
and that the boxes that were packed were her things.
yes.
Okay. Continue, is there more pictures or photos?
Yes, do you recognize the items shown in the photos 8, 9, and 10?
Yes,
Did you take those photos?
yes, it is.
Did you develop those photos?
Yes.
Thank you. I would move for their admission.
Any further objection?
Do have one question. Do you remember the date that those photographs were taken or that are in your hand?
This set was taken December 5th, and there was a second set, very similar, taken February 11th, 2026.
Are any of the photos that are in your hand, are all of the photos that are in your hand taken on December the 5th of 2025?
Yes, and the exact same photos were taken again, February 11th. Less than a week ago. We could go exactly.
I have no objection to the admission of, was it 7, 8, and 9?
I have 7 through 10. 7, 8, 9, and 10. Is that accurate?
Yes, Your Honor.
Okay, plaintiffs 7, 8, 9, and 10 are admitted.
10, I said 9, 10.
I'm sorry, was it through 10?
That's what I have.
Thank you. I'm showing you our proposed plaintiff's proposed exhibit 2A, which includes 3 different text messages. Can you take a look at those and tell us if you recognize those text messages?
Yeah, I can recognize.
And to whom were those text messages sent?
To Jack.
And who sent the messages?
I did.
All right, why did you send these messages?
I was trying to give them a break. But I let them know that as of March 2nd, the full 2,500 would be due on the 2nd.
So when were these text messages sent by you?
October.
October of 2025?
Yes.
Okay, did you ever this text message talks about them signing a contract of some sort. Did Jackie ever sign a contract with you?
No.
And did you advise Jackie on October 13th, 2025, that the housing rate was going to be $2,500?
Yes.
And why was that? Why was it going to be $2,500 beginning of October? Or why did you say in October it was going to be $2,500?
Because Brooke had told me verbally that she was moving in.
When did Brooke tell you that she was moving in? When was that conversation?
August. Same, date that she sent me a text.
Did you intend for there to be, how many contracts? One contract for both of them, two contracts?
Two separate contracts.
And why was that?
I don't know why, but they're two separate people. They're two individuals, both gainfully employed, so two contracts.
Okay.
Two charges.
Did that ever happen?
No.
Okay, and did you ever present them, or did you ever meet with them to draw up a contract or agreement or anything?
No.
All right, so you gave them, I'm going to show you. So in October, sorry, so it was in this communication in October. Did you receive a communication from Jackie about that, about the amount of the rent of 2,500?
November 19th, I believe. Yeah. Saying it's the one that said that we did not feel comfortable.
Okay, that should, did I move for admission of that one,
The people two, I mean, the plaintiff two?
No, I'm gonna withdraw, moving
Two.
forward with two.
Okay.
It should be.
All the ones that you did admit are up here, if you want to grab
I
them.
didn't see the one with the November 19th date.
Is it a text
I have it on
message?
my phone.
No, ma'am, you just be quiet until there's a question, okay? You're looking for the text message, it's right here. I believe 4.
Yes, I'm sorry. Yes. please.
I believe that one was there already.
Yeah, okay, and we've admitted that, but that communication was from Jackie as well.
We spoke to both of them in the text.
Okay, and in the text message, it says, I have not had a chance to get our questions written out yet, but we'll do this. To whom did you believe he was referring when he said our? And that would be
It was confirmed.
by her letter of December 2nd, which is our exhibit number 1. All right, thank you. I have no further questions.
Okay, I think I have some questions for this witness, just based off this. You wanted 2 separate leases, written leases now is what you're saying?
Correct, yes.
Okay, and let's say for the sake of argument that Ms. Sandifer is no longer living there, are you still seeking a lease for Jackie?
Well, he's my son, so he may not. He may go back to just,
Okay, so all of this, that's what I'm trying to get clarity. This is contingent upon him and moving someone else in.
Correct.
Okay, but you can cross examine.
Did you ever present my client or Jackie with a proposed written lease in the past calendar year or in the past year?
No, I did not present him. I told him that I would be preparing one the first of the year,
But did you do that?
but I did not. Wasn't receiving.
Your question suggests that she was living there for a year. That's not what you're trying to suggest.
I'm just asking,
Just what, in the past,
and if, I
since the
think,
time that,
and I believe my question pertained to both Jackie and my client.
yeah, well, you said, you didn't say or, you said and, so that's why I'm asking.
I
If that's what you were,
misspoke.
I'm just trying to make sure I'm clear.
Yeah,
Okay.
I misspoke, I apologize.
Okay.
We saw all of the pictures that were taken on December the 5th of last year. Did you present any pictures that were taken on February 11th of 2026?
Right, so, yeah.
But are they exhibits here in the court? Because I didn't see any.
That one right there. Yeah. They're on my phone too.
Can you take a look at exhibits? I'm sorry, I didn't mean to cut him off. I didn't know if he was done. I'm
He
sorry.
was so frustrated.
Yeah, I am still questioning. Those are the photographs that were admitted. And we already have it from your testimony that exhibits 7 through 10 were taken December 5th of 2025. Are there any other photographs in
Yes,
that spot?
yes.
Let me finish my question. Are there any other photographs that are in that stack of exhibits that were taken in February of 2026?
No, yeah.
Is it true that my client and Jackie requested in-person conversations regarding a proposed lease?
Yes, yes.
And is it true you asked that instead your communications be in writing?
Yes, I did.
And is that why the letter that's already been admitted as an exhibit came into being?
Yes.
Do you know if my client contributed any money to Jackie for help paying rent?
I received $400 from Jackie and my Zelle account.
But do you know if my client ever gave Jackie money to help him pay rent?
Right. Like I said, I received $400 from my Zelle account from Jackie. I didn't receive anything from the tenant. And then in December, I received $1,250 in my Zelle account from Jackie. And I didn't receive anything directly from the tenant. Today I received zero.
And when you say zero from the defendant, you mean directly from my client. Is that correct?
Right. Sort of 2,500.
Nothing further. Thank you.
Can you redo it?
Yes, Your Honor. I'm showing you I'm not sure if I moved to admit these exhibit 5, A, B, and C. I'm not sure if those were admitted, Your Honor.
I believe they were admitted over my objection.
Yeah, they were.
Okay, all right, I'm showing you those And there's some photos that they're not in color, but did you take those photos as well?
On February 11th, I did take these photos.
Okay, I don't know if we can hear that very well. When did you take those photos?
I took these photos on February 11th.
Okay, so the photos that are depicted, the items, were they there in that property on February 11th of 2026 at 2508 Victor Avenue?
Yes.
Now, there's only 4 photos, but how many photos do you think you took on that day?
Probably 1 year more, and also the video by my daughter.
And what other kinds of things did you see in the house along with these photos on February 11th?
The same pack boxes that are in Exhibit 8. There.
Right. And in the photos that are marked 5A, B, and C, was there any furniture that was still there on February 11th?
Yes, there was furniture there, and I also photographed, closet system was still there. Living room furniture was still there. Bedroom furniture was still there. Everything was pretty much still there.
And what was your understanding about who that furniture belonged to?
My understanding that, well, when I visited on Sunday, February 5th, the defendant told me that she had given all the furniture, all the property to Jackie because she had no place to store it. But she did make one exception. She said the pack boxes were hers, and she said her scrubs were at her mother's, which led me to believe everything except for her scrubs were still at the property. By the way, Victor.
So in fact, you did take you inspected the property on February 5th and February 11th, correct?
Correct.
And the items that were depicted in the exhibit that's been admitted as our number 7 through 10 were still there at the property on February 5th and February 11th?
Correct.
February 5th or December 5th?
No, February 5th and again February 11th.
Okay.
Thank you. Did you ever give your verbal consent to Brooke Standifer moving into the property?
I didn't object. She called me and told me she was moving in. I did not object. That's when I started reminding my son it was gonna be 1250. Additional. It was going up. His was going up to 1250. 1250. And then I confirmed it in a couple of different texts.
Okay, and when did you first tell him that? Right after she had just said she was moving in, is that correct?
Yes.
All right.
Well, actually before even, that wasn't just for the defendant, it was for anyone who moved in.
Okay, and approximately when was that conversation with him that if he moved somebody else in, that the rent was gonna be double?
It was ongoing, an ongoing conversation. It's recent as definitely 2024, but it's an ongoing conversation. So,
Okay.
you know,
So this was something that was understood as far back as 2024, is that my understanding?
as far back as before then, before 2024. Even, yeah. Probably 2019. 2019.
And then because you did not receive any rent from Brooke Standifer, is that when you sent the text to say what the rent was gonna be for her as well?
Yeah.
And that was in when?
I sent a text in October. I sent a couple of texts. That's when they said that they did not agree to the amount, that they couldn't afford it. And then, they said they had questions and they wanted to meet, and I said, whatever, it's non-negotiable, the amount is non-negotiable. I said, they said they still had questions, so I said, put the questions in writing. They did put them in writing. 11/19, they said they were working on it. That was the text. And then, December 2nd, I received, an email directly from the defendant. And also attached to the email directly from her was a letter asking about what is the inheritance, what is the mortgage, is there a second mortgage on the property? And they disputed the amount, the increase. They had questions about why was there an increase?
I'm showing you our exhibit number 1. You said a letter dated in December. Is that the letter that you're referring to?
There's one page missing. The page that's missing was the cover sheet. Which,
I believe we provided that already and they were merged into together.
Yeah, that's why I clipped them all together.
okay.
It's just another reason down here's the question.
No, this isn't it. The cover sheet said specifically from Brooke, and it listed her nurse credentials. 3 or 4 different nurse credentials, and it is not here, but it was from her credentials.
Okay, I'm just
So
going
that
to
is-
show
that is
you,
missing.
I'm going to show you our proposed exhibit 11. Is this what you're
You show
referring
a
to?
co-counsel.
Yes, this is
You
it.
show
Oh,
opposing
I'm
counsel.
oh, I'm sorry.
That's it, exactly.
So can you identify our proposed exhibit number? Is this 11?
It's a part of exhibit 1, actually.
May I amend the exhibit, Your Honor, and add this as in addition to
Any objection to that?
1?
None, Your Honor.
It's,
Whatever the
it's
court
amended.
prefers.
Okay, thank you. You referred to a cover page. I'm showing you
Yes.
an additional page. Is that the cover page to which you're referring?
Yes, it's from, says Brooke Sandifer to Wanda Moss, CC Jackie Moss, Tuesday, December 2nd, 2025. From the defendant's account. And it lists her nurse titles.
Right. And that letter references the request by you that for her to pay $1,250
The
beginning.
letter that was attached, here. And the questions, they were disputing the amount.
Okay, thank you. No further
And
questions.
asked about inheritance and mortgages and all that.
No further questions? In light of that amended exhibit, you don't have any follow-up questions?
Not in light of the amended exhibit, but some of the subsequent tests, some of the
That's fine.
testimony, I do have a couple of questions. Prior to your visit to the property on December 5th of 2025, when was the last time you had been on the property and in the house?
Okay, I don't know. It doesn't apply to this situation, so I can't tell you.
When you say, I'm sorry, I just want to clarify, when you say it doesn't apply to the situation, you mean you probably were there, but you weren't dealing with this?
Exactly.
Got it, okay.
But do you know? Was it more than a year?
I have no idea.
I'm going to object to the question, Your Honor. I missed from what date to what date. I don't think it's, thanks for clarifying.
Yeah, maybe if you can narrow it.
Sure. When you went in to look at the property on December 5th of 2025, Had it been more than a year since you had been in the house?
I have no idea when I passed away.
Nothing further, thank you.
Okay, that one is going to be excused. Do you have any other witnesses?
I'd like to call Alvin Moss, please.
Let's have like a 5-minute break.
Yes, please.
Thank you.
reference to our proposed exhibit 2A.
Okay, you can be seated.
Thank you.
Are you still under oath?
Ms. Moss, I'm showing you our proposed exhibit 2, it's 2A, and it includes 2 pages and then 2B. Look at those and tell me if you recognize those text messages. All right, now, one of them talks about rent of 2,500 March 2nd. Can you explain what the reference to March 2nd is?
Yes. The tenant claimed that she could not afford the rent. So I made an exception to the full 2,500 until March. In March, the full of 2,500 will be due on the 2nd, as opposed to the 2 installment payments that I allowed in November.
Okay, so what was the rent to be for Ms. Sandifer? How was she to pay the rent from November until through
She's
February?
supposed to pay it through Zelle on the 16th of November. I received it on the 2nd of November.
Okay, and she was to pay,
Expected to pay on the 16th.
all right, in full on the 16th?
1250 for
12.
her portion.
Okay, and then, so this reference to March 2nd was to ask both of them?
Yes.
Okay. I would move for admission of our proposed exhibit 2.
I don't,
It's non-negotiable.
I need to see it.
Yeah, that's the one that you objected because the daughter was trying to.
It is, but I need to look at this. again. Okay.
You don't have to cover that. That doesn't go into the courtroom.
Pardon?
You don't have to cover that. That doesn't go to the courtroom. It goes into the court recorder, but she can't hear you.
Okay, I've learned the hard way.
Yeah. But we're not that sophisticated in here.
Okay. Force it. No objection to the admission. Are these admitted as just separate pages?
Yes.
Okay.
And this reference.
Okay, so we have 2A, 2B, and then what is this page that's not marked?
Well, this one is a 2-page. Wait. This is a 2-page. This is
So no objections to plaintiffs too.
And no objections to 2A or 2B.
Okay, that's admitted.
I just need to make sure I knew what to. Make sure I was looking at it in the right order.
No problem.
Just one further, well, two question. You made a statement in this text message about non-negotiable. What did you mean by that?
I repeatedly told the defendant and my son that the rent amount was non-negotiable.
Okay. And then I'm still not sure that
In
it's,
terms.
okay. For clarification, there's a reference to March. Was Jackie making his rent payments twice a month? Was that what he was doing?
Yes, and I allowed them that to continue because they said they couldn't afford 2,500. So I allowed that to continue in March. It's going to be due on the second.
On the second of the month, the full
March
2,500.
2026.
Okay, and up until then, they
There's
could
a
pay
paper.
1,200. And what were the dates to be? 1,200 on what date and 1,200?
November 2nd and November 16th, 1250 was due on each day. for a
Okay.
total of 2,500.
Okay, because I'm sorry, I wasn't understanding that myself, so I wanted to clarify that.
Yeah.
So thank you.
Yeah.
No further questions.
President.
I may have a cross-examination, but I need to look at the exhibits. May I approach?
Yes. Thank you, Jack.
No questions after confirming with my client reviewing the exhibits. Thank you.
Thank you, Ms. Moss, may be excused from the stand.
I'd like to call Alvin Moss very briefly.
You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
I do.
You can have a seat, sir.
Mr. Moss, will you state your name and spell your first name?
Alvin. Alvin Moss.
Are you familiar with the property located at 2508 Victor Avenue, Lansing, Michigan?
Yes,
And who resides at that home?
Jackie Moss.
And what is your relationship to Jackie Moss?
Jackie's my son,
Okay.
our son.
Okay. And you are familiar, of course, with the plaintiff here today, Wanda Moss, is that correct?
Correct.
And that is your spouse?
Well,
Okay.
we're divorced. but
Okay,
We're together.
all right, okay. Was there a time in December when you went to the property of 2508 Victor Avenue?
In December, I would say yes, if Wanda was there. I was there.
Okay, so you were present with some of these conversations that you've heard about today in court?
Yes,
All right, and what happened on December 5th? Was there some type of inspection or something of the properties?
okay, yes.
And what happened?
It was an inspection. Wanda was trying to get to see what shape the property was in because he was considering putting it up for sale.
Okay. And did you walk through the home?
I did.
Did you walk through the entire house?
Yes, the one. Yes,
Okay. Were you present when she took some photographs, meaning Ms. Moss?
yes,
And did you see any furnishings in the house at that time?
yes.
Do you know whose furnishings they were?
Some were Jackie's, some was the defendants.
How do you know they were somewhere the defendants?
Because Wanda had furnished the home of Jackie when after she had purchased it.
So there were items in the house that had not previously been there, is that correct?
Correct.
Was Brooke there at that time when you walked through on December 5th?
Yes, she was.
And what was she doing, if anything? If you don't remember.
I
that's
don't
fine.
remember what she was.
Okay. Do you recall if there was a discussion in your presence at any time about the rent, amount of rent?
don't recall.
Did you go back to the home after that date of December 5th?
Yes,
And would that have been around February 1st of 2026?
okay. Yes, I'd say yes.
Okay. I'll give you a landmark. Was it before the Super Bowl? Do you remember?
Yes,
Okay, all right. And did you see inside the house at that time in February?
Yeah.
And I'm gonna show you some photos real quick and you tell me if those items were there when you were walking through. If you'll
Which
just take a
exhibits are
look,
you referring to?
exhibit 5, which is 4 pages, and exhibit 7 through 10, I believe, yes. Yes, 6 through 10. So 5 through 10. Just take a look at those photos very briefly. You don't have to tell me everything that's in them, but just, I want to know if you recognize any of those furnishings.
yes. I recognize it.
Okay, and you saw those there on December 5th as well as February?
Yes,
Okay, thank you. I have no further questions. Did Brooke indicate that the 1 bedroom was her bedroom?
did she indicate that 1 bedroom was hers?
That some of the things in the 1 bedroom were her things?
Not to me directly.
Okay. Okay, no further questions.
Cross-examine.
Isn't it true that on the visit of approximately February 1st, the one that occurred before the Super Bowl, you didn't go anywhere in the premises except the living room?
On February 1st?
Or the one that occurred approximately February 1st, that we know was before the Super Bowl?
I was at the home, I can't say it. This.
If you don't remember, you can always say you don't remember.
Okay, I don't remember.
So you don't remember which specific rooms you visited in the home on that visit, is that correct?
Well, I would have been in the living room, I know that.
How do you know that? Is that because of how you enter the home?
Yes, and that's where Jackie's sofa and TV is at.
Okay.
May I approach the witnesses? If one of these
Absolutely.
citizens is open? I'm looking specifically at the pile of exhibits, photographs that are here on your left that I just indicated with my left hand. Could you look at those quickly?
Okay.
Could you look at all of them?
Oh, all.
Just
Okay.
quickly look at all of them.
Okay.
Do you recall if you saw any of those individual items that are in those photographs on your February 1st visit?
February 1st, that would have been the section.
The visit that occurred in, whatever you want to call it, it's the visit that occurred on approximately February 1st that we know happened before the Super Bowl. The visit that we were referring to when I asked you if you had only been in the living room, and you indicated in response that you did not remember.
Okay. But are we talking, that's been the date of the inspection?
If you guys are calling it an inspection, sure, but I'm asking, did you see any of the items in those photographs on that day?
I don't know.
Nothing further for this witness, thank you.
Thank you, redirect.
Mr. Moss, you were in the living room, I assume sitting down on the couch at one point in time,
Correct.
and you entered the home through the front door, correct?
We normally enter it through the side door. I can't recall if we entered
Okay,
through the front door or not.
okay. And then from the living room, can you see other rooms of the house from the living room?
Yeah.
Can you see the other living room from, there was testimony, there's two living rooms. Can you see the other living room from where you were?
Yeah.
Okay, and at some point in time, did you use the restroom or not? If you recall. If you don't, that's fine.
I don't recall it.
Okay, all right. But clearly, these items were there December 5th at the time of the inspection, correct? Before you
Correct.
walked through. Okay,
Correct. Yeah.
thank you, thank you.
That's all. Any more questions for him? Are you done with the questions?
Yes.
Okay, thank you,
I'm
Mr.
done.
Marsh. You may be excused.
Thank you.
Any other witnesses?
No, Your Honor, we rest.
Thank you. You gonna call witnesses?
Yes, I would call first my client's mother, Lachelle Fuller.
Thank you.
And just as a housekeeping matter, I think he set a couple of exhibits down. Did you grab those? It's on
I
there.
think she just put them up here.
Oh, okay. Losing exhibits is not fun.
Other right. Solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury. I do. Thank you. You can state your first and last name and spell both.
Lachelle Fuller, LACHELLE.
How do you know my client, Roxanne?
I'm her mother.
And have you ever met the plaintiff in this case, Wanda Moss?
Yes.
All right. Did there come a point in time that my client moved in with Jackie Moss?
Yes.
When was that?
I believe it was around the end of October, beginning of November.
And my client's in a relationship with Mr. Moss, is that correct?
Yes.
You know when that relationship started?
Let's see, this is 2025, I believe, January 2025.
All right. At the time that she and Jackie started dating, was she living with you?
No, she had her own apartment.
Okay. And did there come a point in time where she reached out to you because she had to leave Jackie's home?
Yes.
When was that she reached out to you?
I'm not sure of the exact date. I know she had stated she had received something maybe in December stating she had to leave.
So it was in December that she reached out to you?
I think so. I don't know the exact dates.
That's
I
fine.
talk to Jackie and Brooke all the time, so we talk all the time, so I don't know the exact date.
Okay, fair enough. When did she move back in with you?
I don't know the exact date. I know I went to Florida the beginning of January. And I believe the second week, maybe in January.
The second week in January? Were
Of
you still-
2026.
Were you still in Florida?
No, I was home.
Okay. And by that point, Brooke had moved back in with you?
Yes.
Do you know if she started moving in while you were in Florida?
I'm not sure. But Brooke has a key to the house, so she has free access to the house.
Okay. And did Brooke move on any personal property from Jackie's home into yours?
Yes.
How much personal property would you say?
A lot.
Okay.
Several boxes, clothing, shoes, jewelry.
All right, when you say several boxes, how
I'm
many?
gonna object to the relevance.
Well, part of the plaintiff's argument is that my client is still living there. And this is.
Objections overruled.
Pardon?
Objections overruled.
Okay, thank you. About how many boxes would you say?
I believe I've seen about 7 boxes that I've seen, but there's closet space that I haven't looked in. And that doesn't include like totes.
About how many totes would you say are in your home that are from my client?
Maybe 3.
How big are the totes?
There's different sizes. Look, there's some smaller ones, there's some larger ones.
And how big are the boxes?
Most of the boxes are larger ones.
And has my client been living with you at the very least since the second week of January?
Yes.
Okay. Does she periodically stay the night at Jackie's?
I don't know where she would stay. There's been some nights that she hasn't come home, but I know she stays, she hasn't come home at night, so she may be with her girlfriend, maybe at Jackie's, but.
Have you ever spoken with Wanda specifically about any rent that she believes Brooke owes to?
I have not.
Did Wanda Moss ever discuss a lease between her and Brooke or her and Jackie?
No.
Your Honor, may I approach the bench?
Yeah, absolutely.
I'm going to show you what's been marked as exhibits 6 through 10. You can take a look at them. Let me know when you're done. If you know, have any of the items that you see in those pictures been moved into your home?
I would say, based on the shape of the boxes and some of the markings, some of these boxes have been moved in to my home, and the sunglasses, like her tray of sunglasses and the shoes. I've seen those.
Is that it? Okay. If I may approach you with this. That's all right. Were the trays with the glasses and shoes, is that here on exhibit 6 in the bottom photograph?
Yes,
Thank you. And when you said some of the boxes, were you referring to the boxes that are here in exhibit 8?
yes, like some of these ones that are shaped like those, the long ones.
The ones in the top photograph? in
Yes.
exhibit 8?
Yeah.
Absolutely.
Is my client's mail going to your home?
Yes,
How long has it been going to your home?
I would say around the beginning of January. Maybe even before that. I guess I'll reiterate. Probably forever, because that's been her forever home, but whatever mail she had going to the Victor address forwarded to mine, but her main mail has always come to my home. Any mail she had going to the Victor address was forwarded to my address.
During the, in the last, since she moved back in with you in January, has she had any Amazon products shipped to your home? Or anything she's ordered online shipped to your home?
Not sure.
That's fair. Nothing further for this witness. Thank you.
Yes, thank you. Ms. Fuller, did you help Brooke plant some flowers at Victor Avenue? Outside, flowers outside?
I planted 2 plants, yes.
Okay, and that was in July or August of 2025, correct?
I'm not sure when it was. It probably was later than, probably October.
You sure it wasn't in the summertime?
No, because it was towards the end of fall,
What kind of flowers did you plant outside at the end of fall?
a hospice. And it actually was, I talked to Jackie. Jackie,
That's fine.
pardon?
I said, that's fine. Okay, so Brooke acknowledged to you that she knew she had to move, is that right?
Yes,
And you said that was back in December. Or you weren't sure?
I wasn't sure of the date. She just said she needed to move.
Okay. So she was living at 2508 Victor Avenue.
Yes,
And all these boxes and totes that she moved into your house came from 2508 Victor, correct?
I didn't see the transportation of them from the house to my house. So I can't say yes or no to that.
Okay, just a few minutes ago, you looked at our exhibits and you identified things of Brooks in the photograph, such as a tray, shoes, I think
Oh, correct.
sunglasses,
Yes.
those kinds of things.
Yes,
So things that were in those photos
yes,
are Brooks.
yes.
Okay, and they were, if I were to tell you, you don't know from looking at the photo, but if I were to tell you that's Victor Avenue, would you dispute that?
No, I would not, because I've seen them at Victor Avenue as well, yes.
Okay. As far as furniture, you've been over to the address of 2508 Victor Avenue, correct?
Yes.
And did you see Brooks' couch in the living room, in one of the living rooms?
Yes.
Did you see Brooks' dining table at the home of 2508 Victor Avenue?
Yes.
Did you see her bedroom outfit in one of the bedrooms at 2508 Victor Avenue?
I'm not sure. I don't know if I went into, I've only been in the room that had the closets in the main bedroom.
Okay, the main bedroom that had the closet. Do you know if Brooke put that organizer in that closet?
Jackie and Brooke put that organizer in the closet.
Did you see that organizer?
Yes.
Okay, and were Brooke's clothes and shoes displayed in that closet and on the shelves?
Jackie and Brooke's clothes were displayed on both the
Okay.
shelves.
But you don't know, so you have been in that bedroom?
The closet bedroom, yes.
Okay,
And their bedroom, the main bedroom. Or Jackie's bedroom, I guess. I don't know what other bedroom you're talking about.
okay. So Brooke that was her bedroom there at 2508 at Victor Avenue, is that correct? The bedroom that you were in?
Which one you
I'm not
talking,
sure what
which bedroom are you
you're speaking
referring
of.
to?
The one, I'm sorry, the one where the closet organizer was, you said there, that was a bedroom, and that she shared that with Jackie to the best of your knowledge.
My understanding is the bedroom with the closet organizer was her and Jackie, that it had both her and Jackie's belongings in there.
Okay. All right, so she was staying there was living there at the time, correct?
Correct.
All right, thank you. I have no further questions.
Any regards?
No redirect, Your Honor, thank you.
Let's just have a follow-up. Ms. Fuller, you have a communication directly with Ms. Moss at all?
Only when we've been at gatherings, so like for Jackie's birthday.
Oh, okay, so.
Yeah.
Is generally cordial amongst everyone?
Yes.
Okay, and you said that Ms. Sandifer and Mr. Jackie Moss have been in relationship since when?
I believe January of 2025.
Okay. Any other, no questions, you said? Okay, you can be excused. Do you have any other witnesses?
My client.
Okay. You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury. You can have a seat and state your first and last name and then spell both.
Brooke Sandifer, BROOKE, SANDIFER.
You can proceed, Counsel.
When did you and Jackie Moss enter into a romantic relationship?
We actually started dating or talking, I should say, December 2024, and made it more official in January 2025.
And did you move in with Jackie at the house that's at issue in this case?
Yes, upon my lease being up at the end of October, I moved in on November 1st.
Prior to moving in on December the 1st of, was it 2025?
Yes,
Just want to make sure the record's clear. Did you occasionally spend the night at the home on Victor Avenue?
prior to that, yes, we would spend nights sometimes there, sometime at my apartment, just because he had 2 dogs at the time, so we split shifts, if you will.
When did you move your things into this home?
That would have been on November 1st, either, excuse me, I stand corrected, would have been the last day of October, so 31st. That's the day that my lease was up.
So was that when you started moving things into Jackie's house?
Correct. I had a few things there, just, small clothing items, things that you bring over when you are spending the night somewhere, but nothing more than that at the time.
When did you talk to the plaintiff in this case about your moving into the home?
I originally spoke with Miss Wanda in August 2022, August 24th, 2025. We had a long phone conversation in regards to the dining room table. We discussed my moving in, and she was excited that I was helping her son to straighten up the home, if you will. So that was the initial conversation. And then that continued via text message, as I think was, I don't know if those were placed in exhibit or not, but that conversation continued with text message.
Let's start with, what was the conversation regarding the dining room table?
Jackie had a dining room table, which Miss Wanda and I had discussed prior to me even asking her the questions. Was just about cleaning in general, about the type of table it was, the glass inserts and the cleaning of it. She had mentioned that she didn't really like that table very much due to the cleaning of it, from my understanding. So that's kind of what we discussed. And I asked her if we were to remove it and replace it with the table that I had in my home, what would she want us to do with it? As we were, I guess, I don't know, changing things around just because we were kind of coming into cohabitation together. So that's the discussion I had mostly. I did discuss with her the closeting system that was being installed. She mentioned her daughter's closeting system and said that she could get me some of the things that she had in her closeting system. I don't remember what the word was that she was referring to. And I told, I thanked her and we continued the conversation because I was at work that day. Continued the conversation via text message.
Did you keep a record in your phone of the phone call that you had with the plaintiff?
Yes.
At first witness?
Absolutely.
Showing you what I anticipate marking as a proposed exhibit A. Can you take a look at that and let me know when you're done? Done? Okay. Can you tell us what this document is?
So this was just a record of our phone call from August the 24th. We, like I said, talked for an extended period of time. So just 36 minutes, we talked about the home during that entire conversation. That was most of the conversation.
And this is also when you discussed your moving into the home?
Correct.
Okay. And did this, is this a screenshot from your phone?
This is from the T-Mobile app from my
Okay.
phone. Yeah, my call log.
Okay. And you obtained this yourself through the T-Mobile app?
Yes.
And has it been altered or doctored in any way?
No.
I move for the admission of exhibit A. Defendant's exhibit A.
Any objections?
No objection, Madam.
Defense exhibit A is admitted.
I don't know who to hand it to.
Is there, you already marked it? You
Yep,
handed
I
to me.
marked it. I wasn't sure how your honor does it, so
No
I
worries.
brought
That
my
was just only if you wanted her to mark it for you.
I bring my own exhibit stickers. There was a great deal of testimony earlier regarding a closet system. Do you recall that testimony?
Some of it, yes.
When did you purchase that closet system? And better put, who purchased it for starters and when?
So I'm not sure when the exact date of the purchase happened, but it was purchased by Jackie and I, something that we had discussed wanting to do with him utilizing most of the closet space. So we discussed doing that together. So I don't remember when we purchased it specifically. Well,
Was it in, do you remember the season? You started
It would have probably been sometime in late spring, early summer, I would guess.
And did you have a text conversation with the plaintiff about that organizer system?
I did.
Okay. Do you recall when you had that text conversation?
It was the same day as the phone conversation. It was a follow-up from her, what her and I discussed.
Okay. May I approach the witness?
Absolutely.
I'm going to hand you what I anticipate marking as proposed exhibit. Take a look at that. Let me know when you're done. Can you tell me what these 3 pages are?
So the first page was a video of me sending her the closet system. There were no clothing in there, but it just was empty, just showing her that the closet system had been installed.
Okay.
On the second page, she, do you want me to read it or?
You don't need to read it word for word.
Okay, she was just responding and saying how nice that was and how she was excited to see the finished product in the house. And then asked about a mirror that was still there, because we had discussed other properties such as the table. And so I told her I'd seen the mirror and I think I knew what it was and I think we could use it because I thought it was really nice.
Mhm.
And then she just asked me that when I got a chance to send her a picture.
Okay. And is this a text message you had with the plaintiff in this case?
Yes,
And where did you get these 3 screenshots?
for myself.
And have they been altered or doctored in any way?
They have not.
I would move for the admission of these 3 pages screenshot as exhibit B.
No objection, madam. Defense be submitted.
During the course of time that you lived with Jackie. Actually, let me backtrack. In August of 2024, you had not moved in yet, is that correct?
That is correct.
But you were beginning the preparations.
Well, besides the closeting system, the only other preparations were organizing and cleaning the remaining rooms that were at the property. On the property.
Okay. Where is that closet system now?
It is in one of the other spare bedrooms
On the,
at 2508 Victor.
oh, the Victor Avenue.
Yes.
During the time that you were living at the Victor Avenue property, did you ever help Jackie with any rent payments?
I did.
Now, did you make these payments directly to Ms. Moss?
No, I made them directly to Jackie Moss as from what him and I had discussed the agreement from us. So I paid them directly to him for him to pay to his mother.
I approached the witness.
Yes.
I'm going to show you what I anticipate marking as Exhibit C. Take a look at it. Let me know when you're done. Can you tell me what this is?
This is a screenshot from my bank statements from the Zelle payments that I made to Jackie Moss stating that it was for the bills.
And what were the dates of those payments?
November the 1st and December the 10th,
How much were those payments?
$750 each.
Now, I see you have blacked out, or someone has blacked out, 3 other transactions.
Yes,
Who blacked those out?
I did,
Okay. Can you tell me why those are blacked out?
because they were from another party that I was sending money to or receiving money from, actually from my taxes. So my tax guy, excuse me.
And it had nothing to do with the rent, Jackie Moss, Wanda Moss, or the property at Victor Avenue?
No.
Has this been altered or adopted?
It has not.
I move for the admission of the screenshot as exhibit C.
Any objection?
No, you're fine.
Defendant C is admitted.
Were there any other payments that you made to Jackie Moss for help with rent and assorted bills?
He was the one that paid most of the bills and I did the groceries. That was our future agreement. So I gave him $600 for rent. And that was what he was supposed to send to his mom, and then the other 50 towards bills, and then I was responsible for all of the groceries.
So that was the only money you sent to Jackie that was earmarked for rent is in that exhibit?
Correct.
Did you ever get a written notice from the plaintiff requiring you to pay rent?
I did not.
Did you ever get any kind of notice from her that you needed to leave the property?
Yes, in December, I received a notice to leave.
Do you remember when you got that notice?
I want to say it was around December the 12th, roughly.
And what was this written notice?
I can't recall the exact, exactly what it said, but it just said that I needed to vacate the property by January 11th.
And did you do so?
I did.
When did you leave the premises?
January 10th.
And is that when you moved back in with your mother?
Yes.
When you moved back in with your mother, did you leave anything behind at the Victor Avenue residence?
Yes, and that was actually stated to Mr. Alvin Moss when he called me on January 11th.
What specifically did you leave behind? Just from
Furniture.
your memory.
Yeah, some furniture was there. I still had a few clothing items there and a few boxes.
Have you since gone back to get any of those specific items?
Small things here and there that I can take with me, I have, but not any of the larger items such as the furniture.
Okay. All right. And rather than ask you to do this from memory, just, if I may approach. I'm going to start with what's been admitted as I think exhibit 5. You can take a look at these and then you're done, let me know. Can you identify the items that are in those photographs?
So looks like a bedroom set, my bedroom frame.
Okay.
And then a television, some boxes, and a cubicle system, and then dining room table, and then a living room sofa.
And all of those items belong to you?
Yes, except for the boxes that are in the picture with the cubicles.
Mhm.
Those were just things that were packed up around the house prior to moving in.
Do you just, other than those boxes, the other items are yours?
Yes.
Okay. And do you dispute that they're still at the house?
I do.
Okay, so they are still in the home.
They are.
And do you have Jackie's permission? Do you have Jackie's permission to have them still in the home right now?
Yes.
Next, I'm going to show you exhibits, I think, 7, 8, and 9. Or 7, 8, 9, and 10. You can take a look at these and let me know when you're done. Are any of the items in these photographs yours?
Yes.
And if so, can you identify them for us? And could you reference the exhibit number and whether it's the top or bottom photographs? So if it's clear.
So from 8, top photo, I can't specifically say which boxes are mine, but there are some of my boxes in there. Some of them, again, were things that were packed up from the time that we cleaned the home. Same thing in the bottom of exhibit 8. Things that were packed up when we cleaned the home and my stuff. Are in the boxes, mostly kitchen things. That I can remember.
Okay.
In exhibit 7, top picture, the table and chairs belong to me. The bar is something that we purchased together. In the bottom picture of 7, the sofa and ottoman that's there belongs to me, but the kind of miscellaneous stuff, there's like a picture frame and stuff that was there prior to me.
So on the bottom of 7, just the sofa and the ottoman?
The pillows that are on the.
Okay.
Yes. Oh, and the rug. In 6, hard to say, we both had our clothes mixed up in here, but 6, top corner, left third shelf for my pants. The top 2 ones were Jackie's. I mean,
Do the best you can.
yeah. The clothing to the right belongs to me. The hats, 3 of the hats up to the top left also belong to me. The high heels and purses also belong to me. That's in the top of number 6. And number 6 bottom is pretty blurry, but the left side of the island, all of those things belong to me, including the drawer closest to the door closest to us. And opposite side of Jackie, and then I have some shoes. Ten, we already discussed the sofa and ottoman that belong to me, and the table and chairs. And then top right of exhibit 10, those boxes belong to me. The red totes and gray totes.
And what about the bottom?
Just the table and chairs. The other lamp doesn't belong to me. And then the exhibit 9 and the top photo, the bed belongs to me, the nightstand. Luggage on the bed that belongs to me. And then in the bottom right corner, those are things that we purchased together and or was already at the home, such as the base. It's a laundry hamper that we purchased. And then the bottom left, the bed is pictured here. There are a few boxes, some clothing, some luggage, those things belong to me. And the rest, and the cubicle set, sorry.
So the bed, luggage, cubicle set. What about the TV?
The television as well.
Of the items that you just identified in those exhibits that are yours, which ones have you moved back into your mother's home or just moved out of the home in general? Out of
Sure. So the clothing items in 9 bottom corner, those have been removed. Like I said, the one in the bottom right corner, we bought to purchase together, the luggage. And exhibit 10, the boxes down in the basement, top right corner have been removed, that are mine. Everything that was in the closet, so exhibit number 6, that belonged to me, have been removed as well, to my knowledge. Number 7, the sofa, ottoman, dining room table, and the chair still remain. And then in 8, I did remove a few boxes from here as well that I don't remember exactly which ones, top or bottom specifically, but that had been removed as well.
So what's, having had those to refresh your recollection, what's left at the house that belongs to you?
A couch, with the ottoman, along with the table and chairs, the bedroom set, and then I have a few clothing items there that he said I can keep there, just.
Now, were those items moved into rooms that were unfurnished?
So the couch, yes, there was nothing in that room, just a lot of stuff, which is the stuff that we had either gotten rid of, packed up, or garage sale, gave it away, whatever. So there was a lot of stuff in there. There was no furniture in there at the time, though. And then the dining room set, I already discussed with you, like the dining room set, I discussed with Mrs. Moss about replacing that. There was a bedroom set in the guest bedroom that Jackie wanted to sell because he didn't like the mattress. So that is why my bedroom set ended up in there. Yeah.
Now, do you have any objection to taking that stuff out of the house?
No, if it's told to me that I need to do that, then I will.
Would you prefer to keep it in that home? In the home on Victor Avenue?
I'm sure Jackie didn't want his house empty, so I mean, it's my preference to ask him what he would want me to do, but if it's asked of me, I will take the things out.
Let me just gain some clarity. Are these things that you're willing to give to him, you're saying?
He's asking me if that was something that was offered to me. I thought he'd probably be willing to.
Yeah, but are these things that you already told Jackie he could have?
No,
Okay, so they're still yours, but he's having them in his house, is what you're saying?
correct.
Okay. Okay.
If the court were to order that you remove all of those items, the ottoman, the couch, table, chairs, bedroom set, from that Victor Avenue premises, how long do you think you would need?
I mean, again, that's something I would have to discuss with Jackie, because then at least is the places that he does have furnished now unfurnished.
But since Jackie's not here and not a party to this
Sure.
particular case, if the court were to order that you just remove those items, how long would you need to be able to get them out?
At least 30 days.
Okay. Do you have a place to put them right now as we sit here?
I don't.
Object to relevance of that question.
I
it
agree,
goes
it's not relevant.
Pardon?
It's not relevant.
If given the, did you ever have a written lease with the plan?
I did not.
There were a series of text messages between Jackie Moss and various individuals admitted. You saw those text messages here today in court, didn't you?
I saw them today in court, and last night I saw the text messages in their entirety for the first time.
Okay. Did you and Jackie send those text messages together?
We did not. We had a discussion, and the words that were written were from Jackie, not from me.
Okay. Okay, so you didn't review those texts before they were sent to Jackie's mom?
Not that I can recall. You can, if you would show me, I can look again, just to be sure.
Absolutely.
So from exhibit 2A to B, I'm not sure what this one is, so label 2A. I hadn't seen this message in its entirety until last night and today.
Okay.
You said she had not seen that before?
That's what
I
I
had
heard.
not seen
Until,
that.
okay. That is exhibit 2.
To B, to A.
Okay.
And for exhibit 4 and 4A, I don't recall seeing seeing the text message itself, but I do recall the conversation that we had prior to me sending the message.
Did you ever reach a verbal agreement with the plaintiff to pay her rent?
No, we did not. I reached out to her. As a matter of fact, when she came to the home, tried to have a discussion with her and she refused to have a discussion with me. So I spoke with Mr. Alvin Moss instead.
When did this happen?
That was December the 5th.
Do you acknowledge sending the letter in / email that was admitted as exhibit 1?
Yes, that was sent from my email, but Jackie and I proposed the email together.
Let me just stop you real quick. When you said the December 5th incident occurred, where you attempted to have a conversation, was that about rent or was the conversation that you were attempting to have about?
She requested in writing, we requested, well, I asked him to request, I should say, Jackie to request a meeting with his mother so that we can sit down and discuss leasing agreement, rent, etc. She said she processes things better in writing. We sent the letter in writing. So on December the 5th, Mrs. Moss and Mr. Alvin Moss went to Jackie's job. We thought we were gonna have a meeting, but that was an unexpected inspection and appraisal of the home. So that was when I attempted to have the discussion with Mrs. Moss.
Okay. And prior to that, what your position is that you didn't have any communication verbally or otherwise about how much it was expected for you to pay?
Correct.
Okay.
Yes.
Since moving out, have you spent the night at the premises at Victor Avenue?
Yes.
How often per week would you say?
I would say maybe, if I had to guess, 3 times a week, sometimes mostly on the weekends, because he works during the week. And I've been back to the premises to feed him up the dog out on occasions when he is working later than he usually would.
And this is all with Jackie's permission, is that correct?
That is correct.
When did you learn that the plaintiff was the owner of the subject premises?
Honestly, I didn't know until right after that, or either right before or right after that text message, due to the fact that I had conversations prior to with Mrs. Wanda, excuse me, and she did not share that with me, and neither did Jackie. So I would say it was right around the time that we got that notice. Or he got that notice in that text message to me.
And the notice that you received that you had to move out, how was it delivered to you?
I want to say it was via mail. It was, I know it wasn't served. I think it was via mail.
Was it via certified mail or just
Regular mail.
Is there anything else that you think the court needs to know regarding your time spent at the subject premises in Victor Avenue?
Yes, I would say that when Miss Wanda and
I'm gonna object to the form of question. It's overly broad, be made more specific.
It is an open-ended question, but I think she's
I'll
starting.
allow it though.
with Mrs. Wanda and Talise, which is her daughter, came to the home in February, early February, somewhere around the Super Bowl time that we discussed prior. I had a conversation with them during that time. Mrs. Moss stated that if we had given her a 4-month notice, she would have had the lease written up for us or whomever was to move into the home. She did say that it was not anything personal against me, but that she would need 4 months notice.
4 months notice, you said?
Correct. She would need 4 months notice prior to someone moving in so that she can write up a lease. She stated that in that conversation, and so I think that we spoke in August, and she knew that I was planning to move in, and she had issued a lease to me yet, and I didn't know that she owned the home at that time.
So you didn't know she owned the home?
I did not.
Okay, so why did you tell her that you were moving in? Just
because we were close.
Okay,
Just
got it.
casual conversation, just excitement because we had a close relationship.
Got it.
Mhm.
I just have another follow-up question. I'm not trying to really take over, but you did ask her like you were ended anyway.
She did jog my memory about one more question.
Okay, I'll let you do that. I can wait. You can go.
You heard testimony earlier when you were questioned from Jackie's sister regarding conversation about the property you leave behind, the personal property, the furniture and things like that. She indicated that you stated that you were willing to let him have it, that you guys split up. Is that right?
So yes, the conversation.
Let me ask a couple of questions. Did you say that to her?
Not in that context, no.
Okay. Could you clarify what happened?
Correct. There was never a discussion of whether I would break up with Jackie or we broke up tomorrow. There was a heated discussion between all three of us. She stated that my things were still there. And I said, I've taken most of my things to my mother's house, the things that I can bring currently. Jackie has allowed me to leave these things here. And she said, so then if these things are in the house, these are Jackie's then, correct? And I just said, yeah. That was the end of that that part of the conversation. That's how.
Did you ever say that they would be his if you guys split up?
That conversation never came up. Okay. Us splitting up or they would be his, those.
Nothing further.
I do still have a question. This is, I think, where plaintiff admitted as exhibit 1. You stated that prior to, at least until you got this notice to quit, you didn't have any direct communication with Ms. Wanda Moss about what was expected from you to her for rental requirement?
Correct.
So can you help me understand why there was an email that was sent on December 2nd from Jackie and you? And it discusses, I guess, why there is an increase of rent to $1,500.
Yes, I don't mind explaining that. So Jackie, again, I never seen those text messages verbatim, read them from top to bottom. The information was shared to me that the rent was going to increase by $1,500. And then he kept mentioning something about cost sharing and he was confused about those things.
Okay, got it.
So him and I had a discussion about those things moving forward. And then we requested.
Got it. So you're living with your boyfriend. He tells you how much his rent is. At this time, you don't know who owns the property.
Not at that.
When you first move in.
Correct.
Okay. And then would you agree to move in and that you would obviously help?
Yes.
And then somewhere along the line, you learned that his mom owns the property?
Correct.
Do you remember when that was?
I believe that went right before that message was sent.
The December 2nd message?
No.
Let me just say this. Had you moved into the house before you found out mom owned it, or were you, or had
yes. No, I had moved. No. It was 15 days when my lease was up. was 15 days.
So
when
15
this-
days prior to you moving in is when you found out his mom was the
Correct.
owner, okay.
Yes,
And so has Ms. Moss ever reached out to you directly and said you're required to pay me $12.50 a month?
no, Your Honor.
Has Mr. Moss, Mr. Alvin Moss reached out to you and told you you had to pay that?
No, Your Honor.
Has the sister, I can't remember, Talise Wesley, as she told you that you need, that you're required to pay?
No, Your Honor.
Okay, so you're receiving information from a person who's not here, by the way, about how much rent is and what, okay. And I say that because I do have a question, a huge question, about why Mr. Moss was not subpoenaed by either party to be here. But we're gonna address that in chambers in just a moment. You can finish answering it. How about, I don't have any more questions for you.
I do. Exhibit 1, the letter dated December 2nd, 2025. It's from Jackie Moss and Brooke Sanford. And there's a list of questions that are contained at the back, and it clearly says, why are you increasing the cost of rent to $1,500? By $1,500, sorry, why are you increasing the rent by $1,500? Correct? That's one of the questions asked.
I would have to have the exhibit in front of me to actually see.
That's right here. You reach, I gave it to her.
Go to the last.
Yes. I see that.
Okay, and there was a text message on the 19th that indicated what the rent was going to be, correct?
The 19th of the what? I'm sorry.
November 19th, 2025.
Again, that message wasn't to me. I hadn't seen that message. There was from my understanding, there was a message from Mrs. Moss to Jackie Moss that there was going to be a rent increase of $1,500. Yes.
Okay, and by that letter, exhibit number 1, you knew that the rent was going to be increased by $1,500, correct?
This letter was written by Jackie and I.
Right.
So some of these questions were my questions. Some of these questions were from Jackie.
Okay, you didn't read the letter before it went out?
We read it together.
Okay,
Yes.
so you knew about it before.
I knew there was an increase in rent. Yes.
Yes, so you knew that the 1st of December, correct?
I didn't know the dates. What are you asking me? I'm sorry.
You knew that there was a increase being requested of $1,500 by the 1st of December, correct?
No, I did not know there was an increase in rent due by the 1st of December. I did not know that.
Okay, this letter is dated, this letter is dated December 2nd,
That's correct.
and it references that increase, correct?
The increase that I was told back in November by Jackie Moss. That's the
Okay.
increase that's referenced here. That has nothing to do with the December 1st. No.
So you knew that there was an increase, a request to increase the rent by the time you wrote this
Yes.
letter, correct?
Yes.
Okay. And the judge already asked you if you knew who owned the house when you moved in, and you did know who owned the house.
15 days prior, yes.
Okay. Did you pay rent? Did you pay rent to where you were living prior to moving in at Victor Avenue?
Yes, for 7 years.
Right, because you lived there, correct?
Correct.
All right, and so you moved in, you started moving in, I think you said in August to Victor Avenue.
No, I did not move in August. I moved in November the 1st.
Okay, you said you started moving some things in prior to the date that you actually started staying there.
I said that we installed a closeting system. No items were moved into the house prior to November the 1st.
Okay. Your exhibit, defendant's exhibit A says you had this long conversation between, this covers between July 25th to August 24th, 2025, correct?
Yes.
Okay, and you said you discussed the furniture that you were going to be moving in and
No.
the table and various things.
No, that's not what I stated.
Okay.
I stated that Mrs. Moss and I had a conversation about me moving in. Not
Okay.
that I had moved in, but that I was planning to move in upon my lease being up.
So why were you having that conversation with Mrs. Moss in August?
Mhm.
If you didn't know that she owned the house?
Because we had a close relationship. If you read the messages, you can see the closeness in our relationships. We actually talked about cleaning the home and how she had been doing that prior to me coming along and her thanking me for helping me clean the
Okay,
home. So
so
we
you
had a
knew,
close relationship. That's why I had a conversation.
so you knew that she owned the home back in August?
I did not.
Okay. Did you ever give Ms. Moss any money for rent, utilities, anything like that?
All the utilities are in Jackie Moss's name. I gave money to Jackie Moss via Zelle for rent and bills to give to his mother.
Okay. Do you have
For
any-
rent to give to
Do you have any receipts from Jackie for those payments?
It's the exhibit.
Okay. This.
That's
Do you have any
correct.
receipts to Mrs. Moss, like a handwritten receipt or anything like that?
No.
Okay, all right, when you go to make these, you made 200, these are paid to Jackie Moss, correct?
For rent and bills is what it states on the
Okay,
name.
these
Yes.
are not to Wanda Moss.
They're to Jackie because that's what I agree with it.
So my question again is, you never paid anything to Mrs.
Not
Moss,
directly to
Wanda
Mrs. Moss,
Moss.
no.
You never paid anything to Alvin Moss.
Not directly.
So what was your understanding about how much the rent was there for the property?
When Jackie and I discussed it, I never discussed it with Miss Wanda. When Jackie and I discussed it, he had told me how much he, would be paying in rent. And I asked him how much he would like me to contribute. So we sat down and we came up with a number, which is how we came up with the $750 plus I do groceries, all the grocery shopping. Prior to that, though, like I said, I didn't have any discussion with them. I didn't know that. Once I found out Miss Wanda owned the home, then he shared with me things in regards to inheriting the home, things like that. Which is why this
So
discussion.
did you know what Jackie's rent was at that time?
Yes,
And what was it?
$1,000.
Okay. So you just testified, you don't have any payments for $500, correct? You gave it, you paid Jackie Moss $750, correct?
Mhm.
December 10th, after the date of this letter, December 2nd, correct?
Yes,
And you gave him on November 1st, $750, which was after the date of this letter.
So
prior to the
before
date
the,
of the letter.
Oh, I'm sorry, prior to this letter.
Yes,
Okay. So you in fact did know that there was a rent increase by the time
Yes.
you wrote this letter.
yes,
And you don't deny that you did move into the property,
I don't deny that.
and you don't deny that you moved your furnishings into the property.
Yes, some of them, yes.
And well, you went through quite a long list and there's quite a few things in the exhibits, the photos. And I think you've identified most of them as being your property or furnishings, correct? Bed, table, chairs, TV, bar. Well, I'm
No.
sorry, the bar, you said both of you. Pretty much all your clothes.
No, that's not true.
Okay, so you didn't, this wasn't a situation where you just went over and spent a couple nights, correct?
Correct.
You actually moved in,
Yes,
and that was at least in October,
November the 1st.
November the 1st. And you still have property there now.
Yes,
Are you paying Jackie anything for storage or anything to keep those items there?
no, we did not come up with an agreement for that. You did not ask me to do that. You gave me the okay to.
And you're not paying anything towards rent or anything at this time?
Correct.
Okay, so you lived there November, December, January. You moved out, your mother said she thinks you might have moved some things to her property in January, correct?
January 10th.
Okay. But you still have property at Victor as of February.
If you're speaking to the sofa, the table, chairs, the bedding, the bed set, yes.
Okay, you just testified a few minutes ago on December 5th that you asked Jackie to contact his mother. Why did you ask him to contact his mother on December 5th?
I testified that they came by the house on December the 5th, not that I asked him to contact his mother. His mom and his mother and father came by the house on December the 5th, which we thought was a in-person meeting that we had previously requested prior to sending out the email letter, which was requested by Ms. Wanda. We had requested an in-person meeting. She said she processes things better in writing, so we sent her the letter instead. So a few days later, which was December the 5th, they showed up at Jackie's place of work and asked him if he was going home and decided to follow him home. He gave me a call and told me that he thinks we're getting ready to have this said meeting. And when they got there, I was prepared to have said meeting. And in that conversation, I did not talk with Mrs. Moss at all. She did not want to speak to me. I spoke with Mr. Alvin Moss and asked him a few questions about the property.
Why did you ask Mr. Moss about the property?
I asked him what they were doing, and he explained to me that they were doing an appraisal of the home to see if there was any damages or things that need to be fixed for the home. I asked him if he was doing that so that they could sell the property, and he said yes. And so I asked him if Jackie and I needed to find somewhere to live. He said yes. I asked him how soon that would be. He said he didn't have any idea. I then asked if I asked Ms. Wanda specifically if she'd be willing to sell the home to Jackie and I. And she said she doesn't know, she hasn't thought about that.
And when was that conversation with
December
Ms.
the
Moss?
December 5th.
With Ms. Moss?
The conversation was with Alvin Moss and I. The question of whether we can buy the home from her was on December 5th with Ms. Moss. The only answer she gave me was, I don't know, I haven't thought about that.
Okay, did you have any access to the Zelle account to make payments to that Zelle account for Ms. Moss, Wanda Moss?
No, I didn't know what her Zelle account was attached to. That was never given to me. Which is why I paid Jackie Moss to pay his money.
How much of the $750 was for utilities and groceries?
I paid him $600 towards rent, $150 towards bills, what equals a $750, and then I paid out of my own pocket for groceries. That was my responsibility, and he paid for the remainder, bills, internet, wherever else he used it on. Not sure.
When do you intend to get the rest of your things removed from Victor Avenue?
Again, that's a discussion I would have to have with Jackie Moss.
You don't have any arrangements made? I mean, you're testifying here today, it's your property, correct?
Jackie Moss lives, he's a tenant there. He did not ask me to remove those things. That's why the things remain. Him and I had a discussion about removing the things. He did not have a request for me to remove the things. If he were to ask me to remove the things,
okay. So your things are there, you are living there, your things are still there.
Some of my things, yes.
And you're still a tenant at that residence, is that
I
correct?
am not a tenant at that residence. I'm at my mother's home. I have some things there.
But you
Furniture.
have no plans to remove those items from that property?
With the discussion of Jackie Moss, yes.
When I asked you today, you have no plans to a date that you can give us by which you're going to remove the rest of your property from that structure, correct?
I don't have a date, but I can move those things, like I said, upon request. Yes.
Thank you.
You can, redirect, well, actually, let me have her step up, because I actually have to do arraignments. So you can have a seat there. Can I see counsel in my As I said before, I need to adjourn this because I have to do the arraignments. And outside of any redirect of your witness, I think, and unless you had other witnesses other than Ms. Sandiford.
I did not intend to call any other witnesses based on our
Okay.
conversation. Chambers, if you come back, I think Mr. Moss will have to testify.
Oh, agreed. And we did have some, I think, meaningful in chambers conversation about potential remedial measures on this. At the end of the day, there's a familial aspect in this that I think needs to be closely considered. We're talking about a plaintiff who has a son that she obviously loves and cares for. We're talking about a defendant who obviously has a significant other that she loves and cares for. And that person is at the center of this for both of you. And we don't know where this could end, but this right here could be messy. And it sounds like at one point, just reading the exhibits, there was a working, healthy relationship amongst everybody. And so I think the attorneys are going to try to speak to you all off the record about further negotiating a common ground. I'm happy to make a decision if I need to. I will be frank with what I said. I said, regardless of which way I go, I think you're going to lose in some aspect. Even if you win the case, I think you drive a wedge in a relationship that you probably don't want to drive a wedge in. I know your son is not here and he's probably trying to stay out of it, but how far can he really stay out of it if he's maintaining a relationship here? And I'm surmising, but since 2019, it's based off the evidence that I've heard so far, it doesn't sound like no one else has ever been moved into this home. And so to me, this reads as a level of seriousness for him if someone's moving in. So I just feel that there's got to be some resolution that could help make everyone happy. And families are supposed to try to negotiate that without first resorting to the court. But if I need to make a decision, I'm happy to do that. But we're going to try to resolve this, and we're going to engage the common link for that resolution for a number of reasons, based off the way the information and the evidence flowed. He really needed to be here. There was plenty of opportunity that either one of these attorneys could have objected to hearsay because he's not here and the information came from him. But also even some of the decisions I think that need to meaningfully be made in conversations that had either appeared to have only went to him and or need him for the further decision to be made. Even if I take Ms. O'Berry's question about how long or when property could be removed. Well, that sounds like it would be up to Mr. Moss, and he's not here. And so this is what I mean about the interlayers that could become very messy and a wedge that could be drawn that I don't think Mrs. Moss, you want to draw, at least at this juncture, and hopefully it can be avoided. So I think you have some really good attorneys here that could probably try to help get you back to where it looks like you all were trying to go originally, which is some common ground. If that can't happen, then I'll make a decision at the next hearing, okay? Let me get your next court date. Want next available? Yes, please.
February 25th at 10:15.
Does that work for you? February 25th at 10:15? Might be too quick, but
I have my calendar on my phone, so. My client just indicated she's going to be out.
Right. Well, that's fine. We can I recognize it's a week from now, so that if you already have something scheduled, we can move it another day.
Yeah, and I'm double booked that day. Actually.
Okay. Another date? March 4th at 9:30. March 4th at 9:30. What?
That works for me.
So very.
We don't have anything available on the 3rd, do you, March 3rd?
I have a mediation here.
No, that is, I'm thinking it's our city docket. It's the state docket, so we can't do the second. What is our city docket? Right, down. Okay, no. I have to reset some stuff. So that is, okay. So the fourth doesn't work, we can do a different day.
How does-
It works for me.
But it doesn't work for Mrs. O'Leary.
But Tuesday's out. You said you had a meeting.
Tuesdays is our state docket, so
Oh,
that's usually out. We do have some Mondays that we could do. And then what other day we said we were?
How about anything Wednesday afternoon? At the
That's
fourth in the afternoon?
Yeah, because they've done it first. Okay. Does a fourth the afternoon work? Oh, okay, let's do that. What time? 1:30. What time is it? 1:30. 1:30 work?
Yes, what video work?
Okay, the fourth at 1:30.
Thank you.
No problem. We'll get you a notice to appear. Any additional matters for today's record?
Not for today's record, Your Honor.
Well, thank you.
I'll maintain the exhibit. Who's this? Malone?
Yeah, the one that was calling about works.
Is this Mr. Malone?
Yes, it is, Your Honor.
You have a public defender?
Somebody came to me earlier today.
Yeah, he's gotta be on Zoom though. I can't do anything without a public defender.
Are we all set in this matter, Your Honor?
Yes, thank you.
Thank you.
I think we're waiting for the public defender to get logged in.
Someone contact the public defender?
Sorry.
Did someone contact the public defender?
Yeah, he emailed me about 3 minutes ago and I told him.
Oh, okay.
what time we'd be on.
We're just waiting for a public defender to log in.
Okay.
So that will be your paperwork for your next court dates. All those white sheets will have next court dates on them, they should, and then the purple sheet on the back is Zoom instructions. Yeah, I know it's gone now, but it's supposed to be 20 years ago when the same for the bar, we had to pay for it. Customer's office really big. But it is good, so you know, you definitely go into my.
Why am I for this one?
Huh?
Why am I on this one?
Why are you? I'm not sure why they put you in there.
I was gonna ask for justice for everybody, you know? I just want my justice. I just need to be happy. I'm not trying to free the slaves and stuff. You laughing, I'm dead serious. I'm gonna just make sure I find happiness. I would leave Lance and I would run to the village anywhere I could find happiness. Cause this is just too much. Especially the bullying. Nobody got the right to judge for real. They judge out there like they got a gap. Like this, they beg for. There's some people.
Yes.
What?
I ain't never seen them before. I haven't.
Where you from, Lansing?
No,
Why you say it like that? Lansing?
I just work here.
Lansing is where it's at. I was born here. So, he still ain't on here.
No.
Yeah, you on the phone. Zoom in on that call. Oh. I don't know how people know they supposed to have court days to be here, why you not there? As a public figure or a prosecutor, literally, I'm gonna be there.
Hey, do you know who the public defender is? Okay, because we're sitting here on Zoom for Terrence Long and the judge is on here, but the public defender hasn't logged in. Okay, thank you. Yeah. Then I called Trevor and asked him to call their office and be like, fine, you know, yeah, Simmons is logged in, has my first few minutes now, we're just waiting for one to everybody else in the room has their paperwork, Cindy explained it, so we just have to do this. Once they get it all done and then. All right, cool, thank you.
Okay, on the record in the matter of the people of the state of Michigan versus Terrence Malone, 26-00429, appearance, please.
Assistant Public Defender Joseph Hart on behalf of Mr. Malone.
And Mr. Malone is present from the Lansing City lockup via Polycom. Mr. Malone, today's the date scheduled for an arraignment, and I do have a felony complaint here. That complaint alleges that on or about February 16th, 2026, at the area at or near 533 South Chestnut Street in Lansing, Michigan, that you did allegedly commit the act in count 1 of controlled substance possession of cocaine, heroin, or other narcotic less than 25 grams. The allegations is that you did knowingly or intentionally possess less than 25 grams of a mixture containing the controlled substance cocaine, and that this was done contrary to Michigan Compiled Law 333.74032AB. That's a felony. Maximum penalty is 4 years and or $25,000 in fines. There's a count 2 and a count 3. Both are assault and battery. Count 2 upon A. Dejan Najee Richard, and count 3 upon Eliana Renee Sanders. The allegations are that on or about February 16th at 533 South Chestnut Street, Lansing, Michigan, that you did make an assault or assault and battery upon those persons, and that it was contrary to Michigan Compiled Law 750.81. That's a misdemeanor. Both counts 1 and 2 are punishable. Maximum penalty 93 days in jail and or $500 in fines. A consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. Mr. Malone, do you understand the charges read there and the maximum penalty attached to each charge?
Yes, I do, Your Honor.
It should also be noted that the prosecution has filed a notice of intent to seek an enhanced sentence as a third habitual offender under Michigan Compiled Law 769.11. That would enhance the maximum penalty to twice the maximum sentence on the primary offense or lesser term. The maximum penalty cannot be less than the maximum term for the first conviction. Do you understand that, sir?
What charge is this you speaking on, ma'am?
Your count 1, controlled substance possession.
I don't understand. I never had no controlled substance, ma'am.
It says here that they're seeking an habitual offender. It says on or about July 12, 2012, you were convicted of the offense of violent crime, drugs, machine gun in the United States District Court for the Western District of Michigan. On that on or about July 2nd, 2012, you were also convicted of the offense of possession with intent to distribute in the United States District Court for the Western District of Michigan.
I have no recollections of that, ma'am, Your Honor.
Okay. Okay, I apologize that you don't have any recollection, but I'm advising you that you're still being charged and that there has been a enhanced notice provided or intent to charge you as a third offense habitual offender. Do you understand that?
Yeah, I understand you. I'm listening to you now. I didn't never know this was on me.
Okay, thank you. Okay, so you have the right in this matter to be represented by an attorney. Mr. Hardy from the Office of the Public Defender is representing you today for the purposes of your arraignment only. You do have the right to have an attorney with you to represent you at all of your court appearances, and you have the right to counsel if you're questioned by law enforcement. If you can't afford to hire an attorney, you can make a request to have the public defender appointed at the expense of the public. Do you understand that, sir?
Yes, Your Honor.
You have the right to plead guilty, plead not guilty, or stand mute. But if you stand mute, the matter will continue all the way through the stages to a jury trial. You have the right to have a preliminary examination in count 1 because it is a felony. You have the right to have that preliminary examination within 21 days of today's date unless you waive the 21 days or the court waives it by finding good cause to go beyond that timeline. You have a probable cause conference before Judge Cynthia Ward, February 26th at 8:30 in the morning. You have a preliminary examination in person at the court before Judge Ward on March 5th at 8 o'clock in the morning. Do you understand that?
Yes, Your Honor.
At the time of your exam, you have the right to require the prosecutor establish sufficient probable cause that the felony was committed and probable cause sufficient to charge you as the person who committed the felony. You understand that?
Yes.
You have the right to a trial. You have the right to the presumption of innocence and the right to have a trial by jury. At the time of your trial, you have the right to remain silent, not have that be used against you. You have the right to question any witness called to testify against you, the right to subpoena witnesses that will testify on your behalf, and the right to waive your own silence and testify at your trial. Do you understand those rights?
Yes, Your Honor.
And you also have the right to be considered for pretrial release from custody. We'll address your bond at the end of this hearing. Are you currently employed?
No, ma'am.
How do you support yourself?
Family members.
What's your home address?
2712 Gatsby Court.
That's in Lansing, correct?
Yes, ma'am. Yes, Your Honor.
Do you have a phone number?
517 269 1610.
Are you on probation or on parole?
No, ma'am. No, Your Honor.
Do you have any other criminal matters pending at this time?
It's the ones you just spoke about, and the other ones. Oh, man.
The other ones, let's see here. That looks like that was dismissed. Okay. Do you have a retail fraud pending?
It's the other one, yes, the arraignment.
Oh, there it goes. That's right. State of Michigan versus Terrence Malone, 25-03816. Got it. This is a retail fraud 3rd degree that's been pending. You were supposed to be before Judge Ward back on February 2nd, and you failed to appear.
February 2nd, and it was in March. I was in jail February.
Let's see. No, you looks like you failed to appear. There was a bench warrant, and then they reset the arraignment for February 17th at 3:30. It looks like you had a, oh yeah, that's what it looks like. What is he being arraigned on? I'm confused. Did they just put that today?
I thought it went into March.
Failed to appear. I said arraignment was scheduled for 2/17 at 3:30. Was he arraigned already? 2/7. February 9th, there was a bond, PR bond.
He failed to appear for his pretrial on February 2nd. So he was scheduled to be rearranged. He was never rearranged, so.
But they put that note in on February 9th. That's what it says, February 9th, 2026, arraigned 2/17 at 3:30.
I see he was scheduled for maybe, yeah, 2/17 at 3:30.
So he did come in, there was an interim, oh, he had an interim bond. Okay, so we're trying to figure out what happened in this file. So you did fail to appear on February 2nd. It looks like you did get an interim bond, but you were not arraigned for your failure to appear.
And the last time it was supposed to be in March, I was supposed to come back for the next one.
No, you have a pretrial in March, but you were supposed to be arraigned on this. It said yesterday, but we're arraigning you on it today.
All right.
And that was because you failed to appear on February 2nd. Where were you February 2nd?
In jail.
You were in jail?
Yeah.
In what county?
This county, in here. They steady grab me up.
I mean, I'm inclined, let's see here. Looks like you did have a pending case on the third.
They can't grab me on anything.
Sir, give me a moment. Let me see what's going on. Well, there was a felony assault with intent to rob while unarmed. It looks like it was dismissed on the 30th of January, though. We don't have any record of that. I see you had a case that was dismissed on the 30th of January, so they wouldn't have held you after that. Okay, counsel, you can address bond.
Thank you, Your Honor. So, Mr. Malone is someone who has a Lansing address. He is someone that, just looking from the charges that were previously listed, he has prior charges, but those appear to be of a nonviolent nature regarding the possession to intent to distribute and the weapons charges. He's someone that has family in the area, and I do believe that he's someone that is not a flight risk at all. We do acknowledge the two assaultive crimes that are included with this charge. However, I do think that it's possible to ensure the safety of the public through a GPS tether. So I'd be requesting a PR bond or a low 10% bond if the court allows.
Yes.
Okay, I don't have a bond recommendation or report in this file. I do, however, have sufficient enough information that there's a reason why Mr. Malone is behind the glass for an arraignment, and that has to be based on his own behavior. It looks like there was a previous order in the retail fraud third that he was supposed to engage with community mental health. Have you been doing that, sir?
Yeah, I was supposed to be on that all this week. I was supposed to be going there and down there, and then I had an attorney I was supposed to speak to about some LPD charges and go see News 47, Fox 47 yesterday, and I'm just steady being harassed and bullied.
Got it. Okay, bond in the retail fraud is going to be 510%.
Excuse me, say that one again.
510%.
How much is that?
$50.
You can't put me on the ankle bracelet?
Excuse me?
Can you just put me on the GPS?
Oh, don't worry, you definitely get a GPS, just not on that file. On the file number 26-00429, bond is set at 1,010% with GPS tether. You're not to have contact directly or indirectly with the alleged victims in this, that being a Dejan Richard and a Eliana or Elena, that is Sanders. You're not to be within 2,000 feet of wherever they are. Do you understand that?
Yeah, Your Honor.
You're not to engage in any assaultive or threatening behavior. You're not to use drugs or alcohol without a valid prescription. You must report to pretrial services within 48 hours of your release. I'm also going to order that you undergo urinalysis testing for drugs once a week.
How much money do I have to get out?
You're not to travel outside the state without prior approval from the court.
What if I don't got the 150 to get out?
Sir, please don't interrupt her.
You're quite out of luck, sir. I don't know what to tell you. You've got to get a bondsman or you got to get some cash.
All right.
Do you have any other questions for the court?
No, Your Honor.
Make sure you go to all your future court dates. You're all set.
Thank you, Your Honor.
Wait, nope, I got one more.
Oh, okay.
Lord help us. This must be City of Lansing. Is that what that is? Okay, City of Lansing versus Terrence Malone, 26-00401. This one, sir, is an allegation of trespassing. It says that you did allegedly on or about January 25th trespass by refusing to leave or unlawfully remain upon the premises of another, that being the CATA station at 420 South Grand, Lansing, Michigan, and that this was in violation of the Code of Lansing being 660.02. That's a misdemeanor with the maximum penalty of 90 days in jail and or $500 in fines. There's a count 2 of hinder, obstruct, oppose a Lansing police officer in the performance of law enforcement duties at or near the CATA station, 420 South Grand Ave, Lansing, Michigan, and that this was in violation of the provisions of the Code of Lansing being 602.02. Maximum penalty in count 2 is 90 days in jail and or $500 in fines. There's a count 3 alleging that you did knowingly furnish to a Lansing police officer false information, that being the wrong name, at or near the vicinity of the CATA station, 420 South Grand, Lansing, Michigan, during the Lansing officers' investigation of the violation of a state or local law ordinance. And this was contrary to the Code of Lansing ordinance being 602.03 A. That's a maximum penalty, 90 days in jail and or $500 in fines. Again, you have the right to have a trial in this matter, the right to jury trial, the right to the presumption of innocence until proven guilty, the right to counsel. You understand those rights, sir?
I don't even know the charge. You just said at the CATA station.
Trespassing at the CATA. Hinder, obstruct, oppose
What
an
day was
officer. This was on January 25th, 2026.
Was that the day they jumped on me?
You tell me. I wasn't there.
So many charges coming at me, man. I'm kind of confused. I can't think that long.
I don't know. I don't,
2020.
sir, I don't know what day you were allegedly at the CATA, except for what they told me in this. It says on or about January 25th, 2026. It's in your best interest to let an attorney be appointed to help you navigate these cases, and they can give you further information about the circumstances that are alleged against you. Do you understand that?
Yes, sir.
Okay. On this matter, bond is set in the amount of 500 personal recognizance. All the previous bond conditions from your other file will also apply here. You're not to engage in any assaultive or threatening behavior. You're not to use any alcohol or drugs without a prescription. You're not to travel outside the state without approval of the court. You're not to be at the address of 420 South Grand, which is the CATA. You have a pretrial on March 17th at 8:30 in the morning before Judge Ward on that one, okay? Any additional matters for the record?
No, Your Honor.
Okay, Mr. Malone's all set.
All right, thank you.
This was. I'll print the other 3D sentence.
Okay, let's get this one going. On the record in the matter of the state of Michigan versus Daniel Lust, 26-00430 FY, appearance, please.
Thank you, Your Honor. Assistant Public Defender Joseph Hardy, on behalf of Mr. Lusk.
You're Mr. Lusk?
Yes, ma'am.
Okay, Mr. Lusk, I do have a felony complaint here that alleges that on or about February 17th, 2026, at the area at or near 313 West Kalamazoo in the city of Lansing, Ingham County, that you allegedly committed the act in count 1 of weapons carrying concealed. It alleges that you did carry a dangerous weapon, that being brass knuckles, whether concealed or otherwise, in a vehicle operated or occupied by said defendant, that being a 2012 Ford Fusion, that this was done contrary to Michigan compiled law 750.227. Count 1 is a felony with a maximum penalty of 5 years in prison or $2,500 in fines and a mandatory forfeiture of pistols, weapons, or devices. There's a count 2 of operating while your license was either suspended, revoked, or denied, alleging that on the same date and location that you did allegedly operate a motor vehicle on the highway, that being Kalamazoo Street, an area designed for the parking of motor vehicles, the parking lot at 415 West Kalamazoo Street. It says, while your operator's license was either suspended or revoked, and this was prohibited by Michigan compiled law 257.9041. and contrary to MCL 257.9043A, that's a misdemeanor, maximum penalty, 93 days in jail and or $500 in fines, and you're subject to vehicle immobilization. Do you understand the charges and the maximum penalty, sir?
Yes, Your Honor.
You have the right to counsel. Mr. Hardy is going to represent you today to be arraigned, but you have the right to have an attorney representing you at all of your court dates and if you're questioned by the police. If you can't afford to hire an attorney, you can make a request to have the public defender's office appointed at the expense of the public. Do you understand that right?
Yes, Your Honor.
You have the right to remain silent. Anything you say, anything you put in writing can be used against you. You have the right to plead guilty, plead not guilty, or stand mute. But if you stand mute, this matter will continue through the stages all the way to a jury trial. You're being charged in count 1 with a felony. So you have the right to have a preliminary examination. You have the right to have that within 21 days of today's date, unless you waive that timeline or the court finds good cause to go beyond the 21 days. You have the right at the time of that exam to require the prosecutor put forth sufficient evidence that would establish probable cause that a felony was committed, and then probable cause sufficient to charge you as the individual who committed the felony. You are scheduled for a probable cause conference before Judge Stacia Buchanan on February 27th at 8:30 in the morning. You have a preliminary examination in person at the court before Judge Buchanan, March 6th, 9 o'clock in the morning. You should have received a notice to appear and Zoom instructions for Judge Buchanan. Is that correct?
Yes, Your Honor.
Okay. You have the right, again, to proceed to a jury trial, the right to the presumption of innocence. You're innocent until proven guilty. You can maintain your innocence and require the prosecution first prove each element of each of the charges being brought against you beyond a reasonable doubt at the time of your trial. You have the right to call witnesses to testify on your behalf at trial, the right to maintain silence at trial and not have silence be used against you. You can waive silence and take the stand for yourself at your trial, and the right to see, hear, or question any witness called to testify against you. Do you have any questions about those rights?
No, Your Honor.
Okay, he's requesting the public defender's office to represent him.
Yes, Your Honor.
Okay, the court's entering a plea of not guilty on your behalf. Let's see, are you employed?
I am.
Where's that?
I work at the Denny's overnight dishwashing, the one on Saginaw.
What's your home address?
217 North Sycamore, the Rise Recovery.
What's your phone number?
517-420-9209.
Are you currently on probation or on parole?
Probation,
Which court?
Kent County, 63rd District Court.
You can address bond counsel.
Thank you, Your Honor. Mr. Lusk is someone who's lived in Lansing his entire life. As he previously just stated, he's currently holding a job down at Denny's and has a Lansing address. So I would say that he's definitely not a flight risk. I would say in regards to the factor regarding a threat to the community, we do acknowledge the severity of this with it being a felony. However, I would just submit to this court that his past charges based on conversations with him are mostly of the nonviolent nature regarding OWIs and other alcohol and substance related offenses. I don't believe that he's a threat to the community, and I believe that any type of possible perceived threat could be addressed through the use of a GPS tether. So with this, I'll just be asking for a PR bond or a 10% bond if the court allows.
Okay, it does indicate here in the bond recommendation that Mr. Lusk has 2 or more qualifying failure to appears.
Yeah, and I'd like to. I'm sorry, I'd like to address that as well. He has let me know that he's been moving in and out of different homes, struggling with homelessness. This has been a stressor on his mind that he informed me is the reason that slipped his mind, something that was an honest mistake, and also that he, while he may have received notices at the court, he didn't receive any in the mail. This was just a simple case of poor memory, not an attempt to flee this court's jurisdiction, Your Honor.
In addition to that, he's also already under bond and or under court supervision. So really, personal recognizance is not a good avenue for someone who's A, already under court supervision and picks up new cases, and B, has a history of failure to appear, regardless of whether it's because he's trying to avoid or flee the court jurisdiction or if he has a bad memory. That's the whole essence of recognizance. You have to be able to remember your own court dates, and it doesn't sound like that's something that he's doing well.
Understood, Your Honor.
Is that an issue for you, sir?
Oh, are you talking to me, Your Honor?
Absolutely. When's your next court date?
When's my next court date?
Yes.
My next court date as of now is on the 27th, as I see. But yes, it's very hard for me to juggle everything I've got going on, Your Honor. I've got a kid on the way. I'm trying to hold down this job and I'm struggling with addiction. It's been ruining my life, and I'm in the sober living thing, and I'll probably have to go through that again after this. And I really don't want to use these substances anymore. They ruin my life, as you see. I don't want to waste the court's time and ruin what I've been doing, and because I was doing good and I just fell off the train a little bit, Your Honor. That's all.
Okay, well, hopefully you can get back on the train. I think the reality is it's really up to you if you're going to make better decisions, and the courts, both in this jurisdiction and it sounds like in another, are trying to do what they can to give you access to resources. It's about what you're going to do with them. I don't want you to be without your employment. I just want to know that you are going to be responsible for keeping up with your court dates, and telling me that you got a lot going on. It might work in other venues, that doesn't work here because there are
Yeah,
no adults that I know
it's
of that
not-
doesn't have a lot going on. What kind of
Yes.
phone do you have?
I have a smartphone, Your Honor.
Okay,
I do-
stop there.
Yes, ma'am. Yes, ma'am.
Smartphones come with calendars.
Yes, they
Smartphones
do.
also come with alarm clocks. Use
Yes,
it.
ma'am. Yes, ma'am. I
So
will
it's
use this.
it is your responsibility if you're going to continue to pick up various different cases in various different jurisdictions that have different court dates. It's
Yes,
your
ma'am.
responsibility to put your court dates
Yes, Your Honor.
correctly in your calendar and to set an alarm clock. That's your
Yes, Your Honor.
responsibility. And it's also your responsibility to make sure the court's updated if your address changes. It's also your
Yes, Your Honor.
responsibility to make sure your attorney knows how to get in contact with you. And if they email you and or call you on the phone number that you provided, that you don't screen them out and not answer their phone calls. You understand that?
Yes, Your Honor.
I'm gonna give you a PR bond only because I want you to keep your job. And
Yes,
I
Your
want
Honor.
you to go back, and I want you to return back to Rise Recovery. So
Your Honor.
bond in this matter is set in the amount of 1,000 personal recognizance. You are to maintain your employment. Report to
Yes, Your
all of
Honor.
your court dates. You need
Yes, Your
to
Honor.
report. You can't hear me if you're saying yes, Your Honor, while I'm talking. Okay, you need to report to all of your court dates. You have to report to pretrial services within 48 hours of your release from custody. You're not to use or purchase or possess any drugs or alcohol. You're not to possess a firearm or any other dangerous weapon. You cannot travel outside the state without prior approval. Do you have any questions at this time?
Oh, Your Honor.
Any additional matters for the record, counsel?
No, Your Honor.
You're all set, sir.
Thank you, Your Honor.
Thank you. Wait, does he have another file? He has one more.
Coming back up.
I have another case, Your Honor. Yes.
Absolutely. It's the one that you failed to appear on January 2nd for. This is State of Michigan
Sure.
versus Daniel Gus 25-03702. Why didn't you come to court for your preliminary examination?
That's when I was going through that slip again, and I will make sure I get there as on time as I need to be, Your Honor. I promise you. I need this job so I can pay my fines off, and I just need this really bad, Your Honor. I need this.
You have a new preliminary examination. It's on March 6th at 9 o'clock in the morning.
Yes,
Did you get a
ma'am.
notice for that?
Yes, ma'am. Yes, ma'am.
What are you gonna do with these court dates?
I will be there. I will put them in my calendar. I will make sure I have alarms, and I will make sure that I am there on time, Your Honor.
Okay, bond in that matter is reinstated at 2,000 personal recognizance. Don't forget to go to your court dates and make sure you're in contact with your attorneys. You're all set.
Thank you, Your Honor.
You're welcome. State of Michigan versus Zachary Bond in 26-00437. Appearance, please.
This is Public Defender Joseph Hardy on behalf of Mr. Vaughn.
Okay, let's see. Mr. Vaughn has a felony complaint here. It alleges that on or about February 18, 2026, that you committed the act and count one of weapons carrying concealed, and that at the area of 201 West Jolly Road, Lansing, Michigan, 48910, you did carry a dangerous weapon, that being a knife, that was concealed or otherwise about your person contrary to Michigan compiled law 750.227. Count one is a misdemeanor with a maximum penalty of 5 years or $2,500 of fines, mandatory forfeiture of the pistols, weapons, or devices required under the law. Do you understand the charge and the maximum penalty, sir?
Yes, ma'am.
Okay, you have the right in this matter to be represented by an attorney. And Mr. Hardy is here to represent you today. I also am going to advise you of a notice filed by the prosecutor's office of an intent to seek an enhanced sentencing against you as a fourth habitual offender under MCL 769.12. It says on or about September 21st, 2011, that you were convicted of the offense of first-degree home invasion in violation of MCL 750.11A2, and that on or about April 10th, 2013, you were convicted of the offense of second-degree home invasion under MCL 750.11A3, and that on or about April 10th, you were convicted of the offense of second-degree home invasion, again under MCL 750.11A. And these are all in the 30th Circuit Court, Ingham County, State of Michigan, and therefore you're subject to the enhanced penalties if convicted of life in prison if the offense has a penalty, if the primary offense has a penalty of 5 years or more, or 15 years or less, if the primary offense has a penalty under 5 years. The maximum penalty cannot be less than the maximum term for the first conviction. Do you understand the charge and the maximum penalty and the enhanced sentence notification?
Yes, ma'am.
Again, you have the right to counsel. Mr. Hardy's going to represent you today, but you do have the right to have an attorney represent you at all of your court appearances. And if you're going to be questioned by law enforcement, if you cannot afford to hire an attorney, you can make a request to have the public defenders appointed to represent you. Do you understand that?
Yes, ma'am.
You have the right to remain silent. Anything you say and anything you put in writing can be used against you. You have the right to plead guilty, plead not guilty, or stand mute. If you stand mute, the matter will continue all the way to jury trial. You have the right to preliminary examination because this is a felony. You have the right to have that preliminary examination within 21 days of today's date unless you waive the timeline or the court finds good cause to go beyond 21 days. You have the right at the time of exam to have the prosecutor meet their burden, which is to establish that they have sufficient probable cause that a felony was in fact committed and a probable cause sufficient to charge you as the person to allegedly have committed said felony. You have a probable cause conference that's scheduled before Judge Stacia Buchanan. It's going to be on February 27th at 8:30 in the morning. You have a preliminary examination before Judge Buchanan on March 6th at 9 a.m. in person at the court. You should have received the notice to appear in Zoom instructions for Judge Buchanan. Is that correct? Excuse me?
Yes, ma'am.
Okay. Again, you have the right to the presumption of innocence. You're innocent until proven guilty. You have the right to take this matter to trial and the right to have a jury trial in which you will require the prosecutor to prove each element of the charge of weapons carrying concealed beyond a reasonable doubt. You have the right to silence at trial, and they can't use this silence to prove or to imply that you're guilty. You can waive your silence and testify at your trial if you like. You have the right to see, hear, or question any witness called to testify against you at trial, and the right to subpoena witnesses to testify on your behalf. You also have the right to be considered for pretrial release from custody. We'll address your bond in just a moment. But do you have any questions about any of those rights? Is he requesting the public defender to represent him?
Yes, Your Honor.
If the court is entering a plea of not guilty on your behalf, are you currently employed?
Self-employed.
I'm sorry?
Self-employed, ma'am.
Doing what?
Pardon me?
What are you self-employed doing?
Handyman.
You said painting?
Handyman.
Handyman. What's your home address?
I live in a tenant, 1 Perry Robinson Circle.
Repeat that.
I live in a tent in 1 Perry Robinson Circle.
Okay, so so this address as 6820 South Cedar is not accurate?
No, ma'am.
Are you on parole?
Yes, ma'am.
It currently has you listed as absconding from parole. Does he have a parole hold?
The sheet that, sorry.
Yes, okay.
Did anyone call Nancy Hamilton?
Excuse me?
Oh, I was asking them if they called Nancy Hamilton, then
Oh, okay.
during this, I was yelling at a couple of pimps who have been pimping out my cousin and an ex-girlfriend of mine in the woods behind you.
Sir, we don't want to get into the facts right now, sir.
What exactly is going on? Okay, it looks like you're also in warrant status for some pending cases at 56A District Court as well. Let's see. So we'll have you remanded to address all those things that you gotta address. Okay, this matter is pending. You're not to travel outside the state without prior approval of the court. You have to possess a firearm, ammunition, or weapon of any kind. You have to use drugs or alcohol. If you are released from custody after resolving your parole violations and or warrants in 56A, you must report to pretrial services within 48 hours of release, okay?
Okay. Ma'am, how do I file charges against?
We can discuss it later. We can discuss it later.
Do you have any questions for the court?
No, ma'am.
You're all set, thank you.
Oh, right.
State of Michigan versus Jason Garza, 25-00862. I also have 25-02303 SM. Appearance, please.
Assistant Public Defender Joseph Hart on behalf of Mr. Garza.
Are you Mr. Garza? Jason Garza?
Yes, Your Honor.
25-00862 is a domestic violence case that you were supposed to appear for final pretrial. Looks like you failed to appear.
Yes,
Why?
I did. I actually thought my court date was for the 19th and not the 9th. It was an honest mistake. And I understand I still should have been there, but I thought it would be tomorrow, not today. Or tomorrow and not the 9th of last week.
Interesting. How was it that you found out that you missed your court date?
Because I got arrested from the warrant.
Oh, you had an interaction with law enforcement and they picked you up on the warrant?
Yep, for missing my court date on the 9th.
Does he have a new case pending?
No, it was just for the failure to appear.
I don't know. They just picked you up for failure to appear. That's. I got a lot of people that failed to appear. I don't know.
No. I was in a vehicle.
Now it's all coming together. Got it.
Okay.
You also had file number 25. Okay, got it. You also had file number 25-02303, which was also scheduled for final pretrial that you failed to appear on. But again, it was the 9th, and you said that you thought it was the 19th.
It was
honest mistake that could have happened. But do you have a phone?
Yes, I do. I just got a new phone when I was arrested for an original
being charged with this. That was the 4th of January. I didn't have a phone then. And then I didn't get out until the 31st. It still didn't have a phone until last week.
Yeah, it looks like you told the magistrate you had a new phone back on the 6th of January.
But I told her I didn't know the phone number.
Right, it's because you had a new phone.
And so when I got out of jail.
What kind of phone did you get?
I have a Apple iPhone now.
Fancy. I know for a fact Apple iPhone has some features to help you keep up with your court date.
Yes, but I did not have a phone. Can I talk, please? So when I got out of jail on the 31st of January for child support, I was homeless and I had all of my belongings in a backpack. My court dates, all of my papers, my phone was stolen from me. So yes, I know that it has a feature to tell me that, dates and things, but I just thought it was the 19th and not the 9th.
Okay, so your phone has been stolen, is what you're saying?
No, I have one now. I got another phone.
Oh, okay. What's your phone
Another
number?
phone given to me. It is 517-855-6197.
Okay, that phone, I'm sure, has features for you to keep up with your court dates, correct?
Yes, it does.
Okay, your next court date on both is for a final pretrial. It's going to be on the 2nd of March before Judge Flores at 8:30 in the morning.
Yes, ma'am.
Do you have any questions at this time about your next court date?
No, I know I'll be there.
Bond in both matters is 500 personal recognizance, and we're continuing the no contact order between you and Desiree Danshi, I believe. She's the same victim in both files. You're not to have contact directly or indirectly with Desiree Dansby. Do you understand that?
I totally understand it.
You're all set. 500 personal recognizance. Thank you. State of Michigan versus Whitney Rice, 25-03766. I've got some of these files now.
Hello?
Oh, it's our old friend Whitney Rice. Whitney Rice, I have here. You failed to appear before Judge Buchanan back on December 29th for domestic violence. And then it looks like there's a bond violation.
That is correct.
Sorry?
I was taken to the jail on that and posted bond on that and at a place that I've been staying away from that. So I do believe that this was something that was already dealt with because I know I have a court date coming up and I will be there for those. I have a place I'm staying away from the protected party. And the person that called, I guess, or was with the police last time was simply somebody pretending to be that person. So I'm dealing with that as well on the outside of here.
Okay, not 100% sure what you're talking about, but nonetheless, I do have here a bond violation complaint stating that on or about the 17th of February 2026, that you violated the conditions of your bond, which is not to have direct or indirect contact with Parmenter. It says must not have contact. Ms. Rice must not have contact with Richard Parmenter or be within 2,000 feet of wherever he lives, works, or goes to school. The violation is that at the date and time in question, you were present at the residence with Mr. Parmenter.
That's correct. It is my house. And I did file an eviction and didn't have all the paperwork and I'm still working on it. But in the meantime, I have not been staying there and I was simply there to get some belongings. So
it's hard just to let her talk. I'm gonna let her talk too. Okay, let's see here. You have the right to have a contested hearing. You have the right to be represented by your attorney at that hearing. If you're found to be in violation of your bond conditions, you're subject to the penalty for contempt of court, which is up to 93 days in jail and or up to $7,500 in fines. Your bond and the underlying domestic violence can also be revoked, and you could be sitting in jail pending any resolution on the underlying domestic violence charge. Do you understand that?
I do. May I continue staying at the place I was staying at and continue doing drug tests, things from there, away from Mr. Palmer, out of jail until that time, please?
Let the judge speak.
Okay, sorry.
Okay, so we got a couple of issues here, ma'am. Number one, there's a failure to appear in the underlying case, and then the next time the court sees you is because the allegation that you violated the bond conditions by being at the house with the alleged victim.
That's correct. I just was wondering if I could stay at the home that I'm going to be staying at and doing drug tests and staying sober from there until the time.
If you were to get a bond at this point, you are not to stay anywhere within 2,000 feet of wherever Richard Parmenter lives, wherever he works or wherever he goes to school. You understand that?
I do.
Okay. And so you have a new pretrial that's going to be set before Judge Buchanan. You need to be before her March 3rd at 2:30.
And you get a PR bond, please, until then, to deal with these things outside of here?
Amen.
Definitely not getting a PR bond. Like, I promise you, you're not getting one. Counsel, you can address bonds.
Thank you, Your Honor. As the court previously just stated, a PR bond is not possible. However, I would just ask for a 10% bond, and I believe that if she is not currently have a GPS tether, we believe that that would help assure the safety of the community and also ensure her compliance with the no contact order.
Bond and 7. Yeah, Brian said I don't have any money right now, so the only money I got was to stay in my house that they're living in, and I can't be at.
What is your address?
My address is 500 Sprucewood, but right now I have them staying in my home, which I can't be in. They're not paying anything, so I tried to evict them. I'm staying at 1707 East Ellsworth Road. That's where I'm going to be staying and staying sober there and being able to make court dates from that address. I have a phone number that's good there as well. That's not my boyfriend's phone number.
I'm assuming when you say boyfriend, you're talking about Richard Parmenter.
That's correct. That's correct. There's a long ongoing issue there, which trying to prove of identification. We're trying to deal with that outside here.
I don't know if it's the same victim though.
And I don't like to go to school living or anything of that too, if I can be here. I've been staying sober.
Okay. I'm sorry, ma'am.
Maybe get anything to get out of here, and not be in jail. So I could be working on these things with the police in the meantime, or sober living facility, or someplace where I can on each other is fine.
What things can you be working on with the police? I'm not following.
There's identity theft and the whole kidnapping and human trafficking situation that have been trying to file and nobody's addressed.
Got it. Okay. Bond in this matter is set at 5,000, 10% with GPS tether. Again, I'm going to reiterate, there's a no contact order. You're not to have contact directly or indirectly with Richard Parmenter. You have to be within 2,000 feet of wherever he is. Do you understand that?
Yes, ma'am, I do.
Okay, we're also going to make sure that your matter is for bond violation is set for hearing before Judge Buchanan on March 3rd at 2:30, okay?
One more question, if I may. The bond you gave me, will that be reduced if I continue to stay in jail or no?
I don't know what you're asking me.
Like if I stay in jail because I can't post that bond, will that amount go down at all?
It will not. You need to talk to Judge Buchanan after your next court date if you want a reduction in your bond.
Okay, thank you.
You're welcome. Didn't we just see Mr. Book? Yes, I did. I make this up. Get the heck out of here. On the record in the matter of the state of Michigan, I'm sorry, city of Lansing, it should be, versus Aaron Bolt, 26-00427.
Assistant Public Defender Joseph Hardy on behalf of Mr. Bolt.
Mr. Bolt, you're going the wrong way, buddy. Mr. Bolt, I just saw you yesterday. Mr. Bolt, didn't I just see you yesterday?
Yeah.
On behalf of Judge Flores? You had about 10 files or 8 files, so you pled to 4 trespassings, and then here you are again with another trespassing, alleging that on or about February 17th at 8:43 p.m. at the area of 430 North Larch at or near Shiawassee, Lansing, Michigan, that you did trespass on the property or remain on the property of another. You have the right to counsel. You have the right to be represented by the public defender's office if you can't afford to hire an attorney. You understand that?
Yes.
You have the right to a jury trial and the right to the presumption of innocence. You have the right to require the prosecutor to prove your guilt by proving each element of the charge of trespass beyond a reasonable doubt. You understand that?
Yes.
You have the right to subpoena witnesses at your trial to testify on your behalf, the right to call your own witnesses, or the right to remain silent and have it be used against you. Do you have any questions about those rights?
No.
They didn't give me a criminal history, but that's fine. I don't think it's necessary. Okay, counsel, you can address. Does he want a public defender?
Yes, he does, Your Honor. I would
Okay,
be
the court's
pleading
entering
not guilty.
The court's entering a plea of not guilty on his behalf. The concern the court has for this is I just saw him yesterday. There was a litany of files, and in each of those files, he was not granted a PR bond because of his history of failure to appear. And then not even several hours went by and it looks like he was back in custody for a similar or exact charge. I don't know if this is an intentional thing to maybe provide some temporary housing. I don't know what's going on. But I'll let you address bond. Maybe you know a little bit more.
Yeah, Mr. Bolt, I've been with him for several arraignments. I do have concerns about his ability to make it to court. He does suffer from homelessness. He was also shot in the face, and as a result, is very hard of hearing, and is also has very very poor eyesight as well. Continues to suffer complications from the brain injury. From that trauma. So at this point, I would defer to the court's discretion on this, but I did just want to note his struggles with homelessness and transportation for the record.
Thank you. Okay, so the concern that I have is that he does have a trial pre-trial scheduled. It's not until March 17th. That pre-trial is before Judge Flores. I will issue a bond at 310%. I am going to order that there's no PR bond on this file for 30 days so we can ensure that the judge gets to see him. And hopefully resolve this within the 30 days. Any additional matters for the record?
No, Your Honor.
All other bond conditions, including no assaultive actions, and you're not to be at the address in question. Unfortunately, I think that's the address of the homeless shelter, 430 North Larch. You're not to be there while this case is pending, okay? You're all set, sir.
Thank you, Your Honor.
Thank you. There was another one on here, but they didn't give me the files. I'm assuming there's no arraignment for Clayton.
Oh, that was it.
ICJ.
Kingdom County.
Okay, good.
Yeah.
Thank you. That's all we got.
Thank you. Hope you have a great afternoon.